Good evening. Mayor, it's 6:30 if you're ready.
Yes, we are.
Thank you. I have a few preliminary matters to go over. We are recording. This is Zoe Burgess, your city clerk. This meeting is being held with a quorum of City of Westlake Council, physically in attendance at the Westlake Council Chambers at 4005 Seminole Pratt Whitney Road. So give me just a moment. I have some feedback. If you're a call-in user, if you would please mute your device. Mayor Roger Manning, Vice Mayor Katrina Long Robinson, Councilman Patrick Paul, Councilwoman Kara Crump, Councilman John Paul O'Connor are present physically. Planning and Zoning Director Nilsa Zacharias, City Engineer Suzanne Dombrowski, City Attorney Pam Booker, and City Manager Kenneth Castle are physically in attendance. City Clerk Zoe Burgess is attending via communications media technology. Allow me to confirm any presenters that are present and available to speak. Don Hearing of Cutler Hearing, are you present?
Present.
Seth Ben of Lewis, Longman, and Walker, are you present?
Present.
Thank you. Public comments may be accepted at least 24 hours prior to the meeting utilizing the electronic comment card available on the city's website. Public comments are also permitted at the appropriate time during the meeting. The mayor will call for such during public comment, and you may participate at this time utilizing the system's virtual hand feature and waiting to be acknowledged if you wish to comment. Please note this meeting is being recorded, both voice and video, and to remember your mic may be live. I will mute any microphones that carry any feedback or interruptions. However, you can unmute yourself. Any person in the virtual meeting causing a disruption or being inappropriate will be removed from the meeting. If I may also remind those physically in attendance, please utilize microphones so that the virtual audience and a clear recording of the meeting is produced. Thank you. Mayor Manning?
Yes, good evening. I'd like to call to order the regular City Council meeting of the City of Westlake, Monday, November 30th, 2020 at 6:32 p.m. First, I'd like to hope that everybody had a nice Thanksgiving. We had a small one at my house, but it was still very nice. Could we have roll call, please?
Councilman John Paul O'Connor.
Present.
Councilwoman Kara Crump.
Present.
Councilman Patrick Paul.
Present.
Vice Mayor Katrina Long Robinson.
Present.
Mayor Roger Manning.
Present.
We have a quorum.
Stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, do we have any additions, deletions, or modifications to the agenda this evening?
Possibly. So I really want to put this stormwater thing to bed, and considering that a lot of it comes after, I don't know if this is the proper way to do this or not, but wouldn't it be wise to take care of that first, that discussion, before these other items? I've been trying to clear this thing forever.
The council can handle that either way. Generally, you have applicants present for the items that are listed here before. Those should not be lengthy or controversial, so we should be able to get to that item in a relatively quick manner. So most council's commissions have given deference to the applicant, their counsel that are present for the meeting, but that's at the discretion of the council.
Does this stormwater issue affect the applicants?
I don't think there's any outstanding issues on these projects that address stormwater. I'm not aware of any. Suzanne Dombrowski, the city engineer, is here. If there are any concerns, she can raise them. But to my knowledge and understanding, they've resolved those issues with stormwater.
I mean, I've desperately been trying to get closure for this item, and the last thing I want to do is not get it today. So,
well, my concern, I'll make
motion?
My concern was, mine is two parts, so I understand what you're saying. So, council, I'd like to make a motion to move, item A under old business before the section for public hearings. So we can move item A to the relationship above, and then, because my question is, what my concern was, because we have the cease and desist, how do we move forward with that? I know we got a cease and desist from, the attorney, so I'd just like to know how, can we talk about it, can we not, how do we move forward with that?
I suggest we get through these presentations first.
There's a motion on the floor, I'll second it, because it's exactly what I want, so.
I have no objection to bringing this forward. The question is, how do we handle the cease and desist? I think some of those issues will come up in the conversations, and if council needs further direction, we can schedule that. If it's not resolved tonight, to deal with that cease and desist, but hopefully we can get through those issues with the presentation tonight.
Okay. But with the cease and desist out, we can have conversation.
Yes.
Okay. So I'd like to make a motion, move item under old business for section 8 up under public hearing.
Second.
I have a motion made by Vice Mayor Long Robinson, seconded by Councilman O'Connor. Roll call. Councilman Paul?
No.
Councilwoman Crump?
Yes.
Councilman O'Connor?
Yes.
Vice Mayor Long Robinson?
Yes?
Mayor Manning?
No.
Motion carries 3-2.
Okay, we'll move on to public comment and requests. This section of the agenda allows for comments from the public to speak on any item not presented on the agenda. Each speaker will be given a total of 3 minutes to comment. A public comment card should be completed and returned to the city clerk. When you are called to speak, please go to the podium or on your microphone. And prior to addressing the council, state your name and address for the record.
Mayor, I received no previous comments cards. However, there is an item that Tara Dewey would like to speak to. Tara, would you like to speak to it now in the open forum?
No, I prefer to speak on it during the actual agenda item if possible.
Okay. If there are any other public comments, please raise your virtual hand to be recognized. If you're unable to raise your virtual hand, please unmute your device, state your name and your address. Mayor, I have no additional comments.
Okay, thank you. Move on to the consent agenda. This section of the agenda consists of routine or administrative items that require final approval by the city council and may be approved in its entirety by a single motion. There will be no discussion of these items unless a city council member requests such, in which event the item will be removed from the consent agenda and on future agenda. We have a motion to move forward with the consent agenda, or is there someone want to bring up a comment? You have a motion.
Did we approve tonight's agenda? Did we?
No.
I don't think we did. Did we skip that? We're supposed to
There's
approve tonight's agenda, right?
Modification.
Yes, you did the, you approved the
Approve the modification.
Okay, sorry.
Moving that
Approve it
item.
with modification.
Okay. I'll make a motion to approve the consent agenda.
I'll second.
I have a motion made by Councilwoman Crump, seconded by Councilman O'Connor. Roll call. Councilwoman Crump?
Yes.
Councilman O'Connor,
Yes.
Vice Mayor Long Robinson,
Yes.
Mayor Manning,
Yes.
Councilman Paul.
Yes.
Motion carries. Thank you.
Thank you. Okay, do we have any presentations, proclamations this evening?
There are none tonight, Mayor.
Okay, thank you. Okay, so we're going to move on to the city relationship discussion and action directing city services.
You wrote that?
Good evening, ladies and gentlemen of the council. I have a presentation this evening. I'm going to go ahead and give you a hard copy of it so you can be able to look at it while we go through it. It might make it a little easier. And you can take notes on it as well. If I just give it to you to pass it along. And I also have a copy of the recent letter from Bob Dittendorfer, which you probably have all received as well.
Thank you.
You need to get out? You need to get out?
If I can just remind the virtual audience to please mute your devices.
You have breakfast. Why not? Thanks.
For the record, my name is Seth Bain. I'm an attorney for the Seminole Improvement District. I'm here to present to you tonight regarding the relationship between the CID and the city. So I have a PowerPoint to go through with you. I just handed you. A lot of this is information you've seen before, some of the statutes and rules and regulations that addressed at prior meetings and in a letter from Bob Dittendorfer. Before I get to that, I just want to spend a moment talking about what's at stake here this evening and what it is kind of cut to the chase, if you will. The city of Westlake was created to be an efficient, nimble, and cost-effective government to try to avoid the very sort of duplicative bureaucracy that Palm Beach County has become known for, to try to avoid the bogging down of every development approval that comes through. Instead, it was created with this idea that creative and dedicated professionals can create a beautiful, new, creative development instead of trying to strangle it. And that was the concept that guided the city when it was being put together. And when it was, we looked at the fact that there was this functioning improvement district in place, providing services to the residents of this area, to the land here. And it was recognized and decided at that time, which the city attorney agreed with at that time, she was at that moment, that there was no reason for the city to do those things that this competent improvement district was already here providing. That the city would not be double charging its citizens for those services. They would not be subjecting the developers that come here to duplicative and potentially conflicting regulations and reviews. It doesn't mean that there's not coordination between these two entities. We were here at a prior joint meeting, and the CID engineer and the city engineer were here talking to you about the fact that when regulations have been developed specifically for stormwater, they were done, in a sense, in communication between these two parties, in recognition that CID was the one that carries out these functions in the city. CID is the one that has the water management district permit. And CID has a water control plan that defines how drainage is going to occur within the boundaries of the city. And so your LDRs could recognize that and appreciate it and understand that those things are going to be meshed together. And there's certainly no surprise that there's fine-tuning to how all of this had to occur. This is a new city. The development's been occurring quickly. There's new engineers brought on and new staff members, and everyone's getting a feel for what the laws are that are in place. What are the rules? What is everyone's roles? And shining all of this in the best light, that's what's occurring here tonight, is everyone's getting an understanding of how the law, how the charter, how your charter was set up, how those roles were defined, and how everybody will work together to make these things happen. It's been stated to be the goal of most of everyone here, and it continues to be the goal. So here's the bottom line. The Central Improvement District is responsible for stormwater permitting in your city. Every development that comes into the city needs to connect into our stormwater system, which means they have to submit plans to us. We have to review those plans. We have to make sure that those plans conform to our and your regulations that have been put into place, and make sure that they honor the South Florida Water Management District permit that we hold because we operate the system. And then once we determine that that their plans meet those regulations, we give them a permit. Then they construct that system. We review that construction. We monitor it. And when they're done, we go out and make sure it was built to our plans to the plans that they submitted to us. Again, because it's our stormwater system. We're going to operate it. And ultimately, after we've certified its construction, we're going to own it, and we're going to maintain it, and we're going to run it. So the city cannot re-review the stormwater system. It cannot require a separate permit. It can't tell SID how to operate its stormwater system. And it certainly can't label these actions police powers and then claim the right to use it by simply giving it that name. That's antithetical to why the city was created. It flies in the face of the clear language that we're going to look at here briefly. And ultimately, SID's not going to allow the city to review its own system or tell the SID how to operate that system. And I imagine that the developers looking to work here in the city have expressed that same issue. So with that said, do you think we can do this, the next slide? Can I control it? Can you control it?
No.
Zoe
Only
control
Zoe can do it.
Excellent. Very good.
They asked me to not touch this computer. Not touch
Can you rotate it slowly? Can you rotate it slowly?
No,
so I
you
can
can.
see it?
You cannot. That's the reason I asked you, do you want to sit here?
No, that's fine. I've got a print out.
Believe me, they asked me more than once to not touch the computer.
Very good. Very good. Thank you.
So-
Zoe, if you haven't already turned the slide to, please do it.
You want to sit here so you can see the slides? That's what I told you. That's the reason I asked you.
Don't touch the computer.
It's because the camera.
But don't touch the computer. I can see here, but do not touch the computer.
I messed it up already before, so.
I'm sorry. I'm still not going to sit here. I can't see sitting down. I can sort of see it. So, I've got a copy. I've got a smaller copy here.
You want a full-size one if you want?
Despite the fact that having to deal with the readers and the mask fogging up is some of the joys of our current predicament. So, the city attorney put out a memo back in November, and then she continued to address a question that, as we have stated previously, hasn't been asked, and that no one really has any challenge to what the answer is to it, which is, does the city have zoning power? Does it develop its own LDRs? Does it have police power? The answer is, and always has been, yes. So, Zoe, next slide. But the problem is that this question isn't at the heart of what we're trying to get at. The question isn't, what is the city's power? What is its broad suite of powers that it has? The question is, what is it the city's not allowed to do? What is it the city's prevented from doing, and why? That's the question, and it's the question we've been trying to address, and hopefully it's the question we can address this evening. So Zoe, next slide, please. What it all boils down to is the charter that was drafted for this city. And we'll get to some slides later to talk about what the charter is and what the nature of it is. But the bottom line is the charter is what controls your actions, and in it there's a section that talks about the role of the city and SID in your charter. And it's clear and it's unambiguous, and it controls the powers of the city, and it reflects what SID does for the city and for the citizens in the city. Zoe, next slide. And this is that provision. Non-duplication of services. the city shall not exercise any function or provide any service being performed by or provided by the Central Improvement District at any time prior to the transition date. It doesn't take a lawyer, it doesn't take a 9-page memo to describe what this means. Non-duplication of services. Shall not, the city shall not provide any service, provide any function that SID's already providing to the city, to the citizens, to the district. Sorry, next slide, please. And the city attorney's memo suggested that you define this as an exercise of land development rights that the city can or even must do it. It doesn't recognize the simple language of the charter that says that the city does not have that authority or power. Next slide, John. So that said, to dive in a little bit to the actual law and the regulations that we're dealing with here, your authority, the city's authority, like any, comes from a couple places. It comes from the state law, which is the statutes, the state constitution, case law interpreting those things, and your local law, your charters and ordinances. So next slide. Your charter is your law. It's akin to your constitution. It's the constitution for the city of Westlake. It is not a good idea. It's not a guiding document. It's the law of the city, which guides your actions, which all of your actions must obey. When you do things that are not allowed in the charter, you're taking actions that are outside your legal authority. I think in Bob Diffendover's letter, he refers to this by the legal phrase of ultra vires, as an action without power. When you do those things, they have no legal effect. The problem we run into is that when you do that, or when you make a regulation the developer comes in for, and they're telling them to do something, they're in this bind where either they don't do it and the city's going to hold them up, or they do it, and now they've done something that was basically illegal to ask of them. So now they're put in this untenable situation where their permit's got a cloud over it, where it's open to objection, where it's likely to be overturned, where it's potentially going to be in conflict with what SID's asked them to do, and create, again, this untenable, damn if you don't situation. That's exactly what we've been trying to avoid with the city since its foundation. It charters your local law. Next slide, Zoe. There's a mention of the fact that you have home rule power. That is accurate. You do. But what's also important to note is that a charter may limit those powers. A charter, when it's set up, it can discuss the powers it has, but it doesn't have to say that they're unmitigated or unlimited. And in fact, if we look at Section 4 of your charter, yes, it does talk about home rule, and there is mention of that in many of the materials that you've been provided previously. That municipal power also says that, yes, you shall have all the powers of the municipality under the Constitution and laws of the state as fully and completely as though such powers were specifically enumerated in this charter, unless otherwise prohibited by or contrary to the provisions of this charter, unless otherwise modified by this charter. Yes, you have home rule power. Yes, you can limit that power by your own charter, and you have. You look back at that regulation, non-duplication of services. It was made right from the start. The city shall not provide any actions or any regulations, not regulations, any functions, any services that SID already provides. Zoe, next slide. All of these things, I have a few slides here on just the simple statutory construction, the reality that you can't just read a portion of a document. It applies to a couple things. It certainly applies to your charter. You can't read any portion of it in isolation. You have to read the entire thing as a whole. Zoe, next slide. Every part of the law must have a meaning. If you attempt to reason away a clear portion of your document, you're making a strained legal argument, but in reality, you have to give every to the extent that you can. You have to give every part of your law its meaning. So if you sit here and say, I've looked at this lots and lots, and thus this non-duplication of services isn't going to apply here, well, you've now walked away from the plain application of that law. That non-duplication of services has to mean something. If it doesn't mean it for stormwater, does that mean it doesn't mean it for roads? Does it mean it doesn't mean it for water? Does it not mean it for sewer? Then what does that application mean? Where do you apply it? It has to apply somewhere. It applies to the things that SID does. It's always applied to the water, to the sewer. Those actions have already been taking place. Nobody's been complaining about the fact that we provide that role throughout the city. We certify that there's water available. We certify that there's sewer. There's nothing significantly different about the stormwater issue here. So next slide. Again, ordinary rules of statutory construction. The words have to mean what they mean. Zoe, next slide. These ordinances are your laws. As I said earlier, they're not suggestions. They're not things to do. They're not ambitions. They're the rules that you have to follow. And so it's important to recognize that your statutes, your law, your charter, these things regulate and enforce what you do. So next slide, Zoe. In practical sense, as I said at the outset, what does this mean? The charter can live in your home rule. Some improvement district is your stormwater entity out there. You permit your stormwater. We review it. We have a water control plan. We hold the permit. We maintain it. We operate it. The city cannot and does not have a role in this. Next slide, please. With all that said, what are the other questions you might ask? What are the things that you would want to know about this? Is the city prohibited from using SID-developed standards? Absolutely not. And as mentioned, we're working to develop those standards together. SID was in place. SID has a permit with the Water Management District. We have a water control plan. You're able to develop your regulations, and in fact, you have to. So the next question, could you incorporate SID standards either by incorporating the same text or by reference? Yes, it happens all the time. You refer to the statute in your plant regulations. You refer to other SID regulations by reference. It's completely unremarkable. Could you refer to SID's regulations for stormwater? Yes, of course you can. Can the city accept SID certification that the drainage standards have been met? Absolutely you can. So next slide. There's also some discussion about your LDRs and the county's LDRs and your comprehensive plan. The reality is you've adopted a comprehensive plan. That comprehensive plan says in multiple places, and I know we've been through this presentation before, SID's mentioned everywhere in there. The comprehensive plan recognizes SID's role in the city, has from the outset, has recognized the fact that there was an interlocal in place and that SID is the provider of stormwater and water, roads, etc. Next slide, Zoe. And again, back to that question of, can you rely on SID certification? The answer is absolutely yes. Both the Florida Constitution recognizes that two governments can cooperate together to achieve the goals of those governments. And in Florida Statute 163 is the Florida Interlocal Cooperation Act. It has that very recognition of the idea that, yes, a city can work with another district or someone else. The state is replete with special districts. Our firm represents them throughout, and they're often providing a specific service. Sometimes those services are municipal in nature. Does that mean the municipality is doing something wrong by relying on them? No, of course not. It's specifically provided for, and it's what our interlocal agreement recognizes. Next slide, Zoe. When your LDRs are in development, and much of them have been adopted, you have to conform to your comprehensive plan. Comprehensive plan is complete, it's been adopted, it recognizes SID's role in these things. Next slide, Zoe. I'm wrapping up, I swear. Finally, the question was made, is the city at risk of this? Well, notwithstanding the fact that the cities like SID is sovereign immunity in all situations, the reality is that the ruling and the Interlocal Cooperation Agreement Act say the same thing. When you work with another government to provide a service, the liability runs through them. It doesn't run through you. It's not inappropriate. You're not at risk. The cooperation for the Interlocal and the Florida Interlocal Act recognize that. So, last slide, Zoe. So that wraps up what we're here about today. You know, what happens next? Our request is let SID be SID. Let us continue to do what we've been doing. Let's continue to cooperate with the city the way we've been cooperating. Allow us to operate our systems, to permit them, to regulate them, to not subject the people that come to your city wanting to do new development to be caught between, you know, not knowing where to go, where to turn, or being afraid that once they've complied with SID for water, for stormwater, for any of these other things that we do, that they're all of a sudden going to be blindsided by a new set of regulations, a new set of rules, some other requirements that, you know, that quite frankly, SID's not a part of and can't continue to allow to happen. So as was mentioned, we've sent a Section 27 letter under our agreement to you. That's for a future agenda item. But hopefully we can resolve this question and the city can just agree to allow the city to continue to do the work it's doing for your citizens under the charter. Thank you.
Thank you. Questions? First, I have a question. At a previous meeting, we had the city engineer and the city engineer working, gave us a presentation and we'll come up with a plan and or an answer to our issues. Are we resolved with that at this point?
Good evening, this is Suzanne Dombrowski with Chen Moore. We're the city engineers. At this point, we have a set of regulations for the stormwater section that both the city engineers and the CID engineers are in agreement with. So this does not speak to as to who does what, but it's a comprehensive set of regulations for the applicant to abide by. Does that answer your question?
Do you agree with that you can allow CID's engineer to approve any stormwater documents that have to be done legally?
So from our perspective, it depends on what the engineering department is being asked to do. So if we are being asked to verify compliance with the city code or the city comprehensive plan, then we believe that we need to review it. If we are not being charged with that, and CID is being charged with that effort, then we don't feel that we would need to review it.
I have a quick question. Yeah. So maybe it's a statement, I'm not sure, but from what I gather, you guys agree. It's just the attorneys that don't agree. Is that where we're at? You can go. You guys are on the same page from what I gather.
And for the record, I don't know if I need to be sworn in. Brian Wheeler, Culper Wheeler, Seminole Improvement District, district engineer. As far as the code and the way the code's going, when you put both our code and the city's code together, it is almost exact. I mean, there's just some very minor differences, nothing technically wise that makes a difference. The only thing I will say from CID's perspective, as a permit owner, we have to look at everything. So that's, I guess, the only difference. But as far as the legal and the stuff that's within these two documents, all kind of ambiguity and differences have all been cleared up, and we're basically at that final, the finish line's right there up the road. Based on us kind of going back and forth since our last meeting. So that's all. Thank you.
Yes.
I'm sorry, I forgot your name already.
Yeah.
Something with me. Can you give me the definition of land development?
Not off the top of my head, I can't give you the statutory definition of it.
Well, I took the time to kind of look that up, and in the explanation, and for Wikipedia, for what it's worth, it lists drainage as one of the responsibilities for land development, which then falls under the city. You've talked in great length about the stormwater drainage. As I understand all of this, stormwater or the stormwater drains, I don't think it's so much an issue rather than the pipes that go from the house to your stormwater system. That's how I understand this whole situation, which then in my opinion falls again under the city. You've said that the city can accept its rules and regulations and standards.
No, they can accept the certification that the plans have met all the regulations, including your own.
Okay, so what are we doing if the city has a higher standard for whatever reason? And what are we doing? Who's then responsible? Who has to say so?
First of all, you have the right, you have the ability to pass whatever regulation that you feel is appropriate. That's not the question. The question is, who's going to review the plans for stormwater permitting, and who's going to certify them?
Okay,
and so whatever those regulations are, you can do it. Now, more to the point from your first question, for what defines land development regulations, I also want to make the point that, as it states in your charter, non-duplication of services. It doesn't say non-duplication of services except for land development regulations. It doesn't say non-duplication of services except for police powers. Now, to a certain extent, that fact can be true. There's no limitation on your charter on that. It says non-duplication of services. We review and permit stormwater in the city.
Okay,
and we always have.
But the thing is that there's a duplication of services, I guess, would be if the city were to construct their own stormwater system, charge people for it, and so forth. There will be a duplication. Land development, however, is a different issue.
I just want to kind of clarify something that's a little bit different than most cases. So if you compare City of Westlake and Seminole Prison District to, say, Palm Beach County. Palm Beach County, all the lakes, all the piping, everything interior to development are all private systems. In our case, all the lakes are permitted, designed and permitted to meet SID specs, but also turned over for the ownership of SID. So it's not only handling the stormwater that's coming in just from the individual developments, but these developments, because the whole system is interconnected, is actually acting as quote-unquote conduits that is taking the overall stormwater management system for the entire 4,000 acres that's coming through. So it's not just a simple, development by development basis. We have that difference where the lakes and everything are owned and maintained by us rather than say, an HOA, where then the city would be, having that extra oversight to make sure that HOAs are maintaining and doing all the maintenance, the ongoing maintenance on those systems. And in this case, it's Seminole Improvement District that has to do it. So that's why, not only do we review everything, but we're having to make sure, the ongoing maintenance is done, because we're the ones that are ultimately going to be called.
Okay, so what are we doing if there is a discrepancy? If the city engineer finds that, for whatever reason, something, a pipe needs to have a few degrees more angle or a little bigger, whatever the deal is, whatever the scenario might be, what are we doing if there is a discrepancy?
If they're meeting the code, there's no discrepancy. And right now, what we're going to and what we're working to is all the codes meeting and matching and meeting, not only the codes and the comp plan, but also the South Florida Water Management Permit, which ultimately dictates what the stages and the elevations and stuff should be.
So are there any different codes or standards from the city versus?
So before we got to this point, we were operating under the county code, and SID had a different set of standards.
What were the standards? Were they lower or were they?
It depends on the specific. It would depend on the specific component. There was a lot of detailed items that we would check. So in the past, there could be discrepancies between what we would require. For example, the county code might be more strict and require something that the SID standards didn't speak on. But that's why at this point we've developed a set of standards that we think is the same.
The same between the two.
Same level of standard. So one is not higher than the other.
Do they deviate from the county code?
Yeah.
Slightly, yes, but we both believe it's in the best interest of the city and SID what we've developed so far.
Yeah, so can we legally deviate from the county code? Because ultimately we have to answer to the county and the state.
We can when we adopt our own version of Chapter 5. Right now, what we're using is Article 11 of the ULDC, which has the higher standards, but it's off the original reference there.
So what we have been developing is for your future article that you would be adopting, but currently we're charged with reviewing everything in accordance with the county one at time of incorporation.
And in most cases, we're either at or above what the county requires as far as stormwater management system. And that's set forth in the comp plan, which both of our codes now, because what happened was originally, typically what happens is you use a code that's set in place like Palm Beach County as your, starting point for your code. So what we've been working on doing is modifying this code to make it specific to City of Westlake and Seminole Improvement District. This follows what was stated in the original comp plan and also states or follows what's in the South Florida Water Management Permit.
Where we, in regards to the ability for the city attorney to review plan, if there is a question that arises for whatever reason, does the city attorney, does the city engineer, I know she has the ability, but will Sid grant her to review those papers if she asks for it? I do not want her to be left out. If there is a question and she wants to review those papers, it is to me the utmost importance that she has the ability to see those in time and review them if she has to.
In my opinion, that's up to the lawyers to decide. But at the same point, we will be reviewing and, cross-referencing the submitted applications to what's set in the code. So that's, between the lawyers with whether or not what's, whose responsibility. But in our mind, we have to review it regardless because of the stuff as a co-permittee on the South Florida Water Management Permit. So that's, not an answer we can give, but, in our opinion, it's stuff we have to do and are required to do.
Now, I have one more before you start. I have one more question when it comes to the cost. Talking about duplication of service and costs. With that, I asked the city manager to provide me with a number. He has not. And I've brought that up in meetings before. Maybe you can give me a number. What is the cost of the city engineer reviewing those papers versus the cost that Minto paid to sit for lawyer fees?
Again, the cost, the answer, I don't know the answer to that. I mean, engineers are expensive, I can tell you that.
Well,
but my point is,
we sitting here
but that
all the
question,
time talking about the city has to pay more, the residents have to pay, which I don't believe is true because it's really ultimately the developer. But we're talking about we have to pay, and nobody as this far was able to give me any number as to what it costs the city for the city engineer to review those papers. We can't constantly say and build up this cloud and say the city has to pay when in fact they don't, or if they do, how much it is. And I'm very sure that even though engineers are expensive, a lawyer is even more expensive. And Sid has paid, I know, has gotten a great sum of money, or paid a lot of money for the lawyers. Minto has paid the money for the lawyers. So.
And the point I wanted to make this evening, and I tried to, was that it's not about the cost necessarily. It's about the authority of the city, and it's about that non-duplication. Yes, there's a cost element involved, certainly. But when all of this came to head, it wasn't because, some developer didn't want to pay a few extra dollars. It was because he couldn't come to a situation where he's got a permit lined up, he's got plans reviewed, and now someone else is going to tell him to do something differently, to start over again, to modify his plans when he's there when he's got the SID permit, or when he's ready to get the SID permit, and now the city, which does not have that authorization, is going to put a cloud over his permit by asking him to do something different. That's the situation right here. It's not about the money necessarily. Yes, we want to be efficient, we want to be nimble, we want to be non-bureaucratic, we want to reduce the duplication of costs, whatever they may be. But more importantly, it's about the authorization of SID to do what SID does. In fact, the city does not have the power to do that. Just briefly to your prior question, I certainly think, that the cooperation amongst the city and SID remains. There's no question that if SID had a question about the city's regulations, there's no reason it wouldn't reach out to the city's engineer or the city's attorney or the city manager to get clarification on that regulation. Nothing here is suggesting we're not going to continue to cooperate in the spirit of moving this project forward. That's what we're all here to do.
Well, it's not about the suggestion, it's what happened. The city engineer has been denied access to certain plans and to review them.
It's not the city engineer's responsibility, is our position. If we had a question for that, we would certainly reach out to them.
I will say not denied from SID. Those requests are not coming from SID.
I get it.
Am I correct in thinking that until we develop our own LDRs in Chapter 5, that we're still obligated to operate under Palm Beach County standards?
You are obligated to operate under Palm Beach County standards. There's certainly no reason why SID wouldn't be able to carry out the review subject to those standards, and has, and does.
Suzanne has stated that you guys do have a set of regulations. You've come together and decided on set regulations for two parties, both parties. So now we're just deciding who reviews those, correct?
Yes, that is correct.
Okay.
And the only thing I'll say from SID's part is regardless of the outcome, as permittee, we still have to review all these documents. So.
Have you approved, as SID approved, your board, changing any regulations that needed to be changed in order to come together on this agreement?
Not yet, no. So we've been drafting and going through and doing the, changes to the codes to make sure that it meets, they're meshed together and also meet the comp plan in the South Florida climate.
So
once there's LDRs in place,
yet.
Once there's LDRs in place, we'll be amending our water control plan, which we really need to do anyway in light of the speed of the development that's been occurring out here. So we need to update some schedules and some tables, et cetera. So we'll be addressing that at that time. Yeah.
Those plans and rules and regulations, whatever, do they at this time address the entire 4,000 acres, or is that just based on the phase that we're in or phase that we're about to be in?
Sorry, say that again?
You're saying the standards and rules that I guess you all agreed to, or hopefully agreed to, do they cover the entire 4,000 acres, or is it just for whatever's going on in groves or?
So the standards that we've developed, the intent is that they would be applicable for development of the city for full build-out. I mean, things always happen where you need to modify standards, but that's the intent going into it. Brian can speak on the water control plan.
Yeah, I mean, that's, as Seth was saying, basically we're going through currently the modification of that water control plan to update to what's been constructed up to this point, and then also, what potential changes have happened since the last one was 5 years ago.
What happens if your board says, no, don't do it, or we're not going to accept this?
Accept what?
Your recommendations to change whatever needs to be changed, come together.
In my opinion, there's not much of a difference because we still have the South Florida permit that we, that sets, so we have the South Florida permit and then the existing, code requirements, which really, there's not any substantial differences. So in our minds, there's not much of a difference because we still have to meet those requirements.
A robust conversation, a series of conversations. First of all, I like to acknowledge that I do like the fact that two of you have come up together. We were not here last month. And so I can appreciate that you have identified that you have a comprehensive plan in action I would like to ask you a question where you talk about the city. It was your second to last slide on our PowerPoint, where you talk about the city not liable, liability is not at risk. I want you to go into that a little bit more and tell us what you mean by city liability is not at risk.
Certainly. Again, at the outset, again say we are co-equal governments to the extent that sovereign immunity applies to both, and so there's a certain protection there. However, both courts have found that when a municipality, and I've got a citation here, that when a municipality has transferred its responsibility in a specific department, that it cannot be liable if the other government failed to perform it. Or more specifically, and this is what really speaks to the heart of what we have here, is we have an interlocal in and amongst the CID and the city, is that the Florida Interlocal Cooperation Act, Statute 163, clearly says, except to the extent of actual and timely performance by one of the parties or any legal administrator, in which the performance may be offered in satisfaction of the obligation or responsibility, which is to say your obligations and responsibilities, when they've been transferred to CID, have been transferred fully. You don't retain that responsibility. The obligation is ultimately you see language on the plats without recourse to the city of Westlake, and that would be the phrase you hear that CID's stormwater is the stormwater permitting entity. We own the lakes, we own the system, we maintain it, we operate it without recourse to the city. Someone has a problem with it, they've got to come to CID. You might still get the call, you're a city council member, and your name's on the website. The answer will be, you pay a special assessment, we have a special district, they handle that, here's Ken Castle's number.
My next comment is always for council comments about it.
I'll just take a moment. Vice Mayor, you really took the words right out of my mouth. I want to thank you guys for coming together and you worked very, very diligently. You put in a lot of hours. Thank you.
And I must say, Suzanne was, great to work with. She did, at the beginning, a lot of the beginning kind of legwork. So I would like to thank her.
It's just so wonderful to hear that everyone's working together. I'll reserve the rest of my comments as well.
Any other comments? To the attorney.
Looks like Ms. Julie has some comments as well. I want to try to respond to some of the questions that have been raised here by council.
I don't want to belabor any of the points, and I do think that we have all really worked hard to cooperate on this, and I think Councilman Paul had said at one of our last meetings, I have just such a big deal. And from Minto's perspective, first of all, I should say my name, I apologize. Tara Dewey, I'm a Luke Longman Welfare on behalf of Minto PDLH LLC. And, really, from our perspective, there is nothing in it for Minto for you all to adopt regulations that we don't think are legally compliant. Because if you adopt land development regulations that are not legally compliant, our approvals are in jeopardy because they've been approved under a regulation that doesn't meet the terms of the law. But all that being said, we have all worked really hard to come up with standards, and I'm just to be really clear. You guys are currently operating under the ULDC. You have adopted your own comprehensive plan. You implement the ULDC consistent with your comprehensive plan. You cannot implement portions of the ULDC that are inconsistent with your governing laws and your comprehensive plan. So that's the current state of affairs. That's what you're doing. My comments are more directed towards what we've all been working towards, which is the adoption of your own land development regulations. Some you've already done, I think, 3 or 4 chapters, maybe more. So this is one where it kind of hit a road bump. And Minto's position has been, look, we just want one set of people telling us what to do on these issues. When it became clear that there was an impasse and disagreement, we entered the fray to give our legal opinion about what we think. And I've provided that to you. I'm not going to belabor it. Because I think what's more important is to talk about, Councilperson Paul, you asked, well, what is the land development regulation code or land development regulation? Well, it's not what Wikipedia says. It's defined in the Community Planning Act, and it's in 32.2. I can pull it back up. I just had it. and it says you have to provide for drainage. That doesn't mean you have to actually be the person who's certifying and regulating it. And the best way I can explain this to you is to provide you examples where other people are doing this.
Can I stop you right there for just a second?
Yes.
I'm sorry, don't mean to be rude.
No.
But when you say provide for, and it doesn't mean city actually has to be the one implementing it.
Correct.
Doesn't that, however, still mean that the city has oversight?
Let me use an almost parallel example. See that big road out there called Seminole Priority Road? It is in your jurisdiction. The same law that we're talking about, the Community Planning Act, that defines that you have to regulate or provide for drainage, also requires you to provide for transportation systems and to regulate transportation systems. Well, the county has usurped your home rule power in its own charter, similar to how your charter prevents you from doing what SID does. So it's the same concept. They have usurped the power for cities within their jurisdiction to regulate regional transportation issues. That's a county road you can't regulate. That doesn't, so what do? And you'll get there. What do? You adopt a code, and I can print out, I didn't print out examples of this, but I can. You can adopt a code that says you must comply with Palm Beach County Transportation Performance Standards, and we require certification from Palm Beach County that you meet the standards. That's exactly what we are recommending you do here. What does that do? It lets the county retain its jurisdiction as the sole exclusive jurisdiction over those issues. But it makes that part of your land development regulations which you can enforce. And if the county does something crazy, you show up at their door, and they do a lot of things. So that's what we're proposing. So my colleague, Catherine, is going to be my Vanna White, so I can answer any further questions. What I provided for you, and I just want to go back one before I talk about these examples. Your comp plan also, so drainage is a concurrency item in the land use world. So is water, transportation, and drainage. You guys already rely on SID certification that potable water and reused water can be provided. You don't do anything about it. You get a letter from that says you get it. This is no different. So it's not as complicated as we've all been making it. In the end, you're right. The engineers, once they sat down, and frankly, we were part of that. The private developer was part of the discussion, and we never didn't give them information. It was making sure we gave it to them in a way that they could understand it. So we felt all that. We're on the same page, and I think that the examples we provided you show you that in every jurisdiction in Palm Beach County, except Barney Breezes, because we couldn't get their code, they incorporate by reference. But more importantly is the first example from Coral Springs. If you look on third page, in section 250202 of the Coral Springs Code that we printed out for you, and these are excerpts, it says, with respect to the determination of concurrency for drainage capacity, where the city of Coral Springs is not the service provider. You guys aren't the service provider. The city shall rely on documentation provided by the applicable water control improvement district. So this concept isn't new. It doesn't need to be this complicated. But the problem is, and the reason that we're in this fight, is if you do something ultra vires, if you do something that isn't permitted by your charter, exercise a power you don't have, it jeopardizes your code, and it jeopardizes all the development you approve under it. And so we can't. We wanted it to get worked out, but without us, and we frankly didn't enter the fray until later. But I think you have here a bunch of different examples, and I just got these together in advance of this meeting, so I apologize I wasn't able to share them with your staff in advance, but more than happy to sit down and have further discussions about these examples. But I think there's a way to get there from here by just incorporating the standards, accepting the certification, and to the extent something goes haywire, to answer your question.
Mayor Manning and Archbishop Hall. You have an interlocal agreement that has dispute resolution, and I believe has a provision in it that you can take over if they fail to live up to their duties. So.
Well, the take over part is again, you know, it's my hang up and all this. I get all of what you say. This works with standards. I get all of that. My hang up and my problem is this stance of saying it is basically saying it's none of the city engineer's business what we do with drainage. You have to just believe that we do whatever we do to the standards that are set, and that's that. So by you saying that if we believe or the city believes that there is something that needs to be addressed, well, kind of left in the dark because, well, we can't review the plan. So that's where my problem is. I get all of that. I really, you know, we built the pipe. Do I care? Not really. But well, the city has to have the ability, if needed, to review a plan. If there's something that's clearly not a problem, fine. Well, but if there is a problem, then.
Can I make a suggestion? I mean, this is disturbing.
Sure.
I'm all about fixing. So, you know, unfortunately, and I'm not saying this to be rude, but it's just the state of the law. And I think you could call Palm Beach Gardens right now and ask them how they feel about not being able to do regional transportation concurrency, and you'd understand that they've adopted a mobility fee and are in a big fight with the county about this issue. So I understand you don't like it. I get that, because it seems like you don't have the power to control that particular issue. And from a legal perspective, that's true. From a practical standpoint, however, you have an entity who has the same goals as you and who you will be absorbing. It's going to become an independent entity as you. And so to the extent that you have these concerns, I'm sure there is additional provisions you could get into an additional agreement with BID that would deal with this particular issue if that was the big concern. But it doesn't change the state of the law and what powers the city has and what powers the city doesn't. So I think there's other ways to address those concerns that don't jeopardize the regulations that you adopt to apply within the state. I don't know if that answered the question or if I can answer the question, but that is, I think, the perspective. Anything else? That's all I have. If you have any questions, I did send you a memo. I have been doing purely land use for 15 years. I have that statute memorized, so if there's any questions about that, I'll pop up again, but I know we won't.
Mayor, to respond to a couple of the questions, first, Councilman Cole asked a question, how does land development regulation define? What is it? That was provided to the council previously in the PowerPoint presentation. I provided it to you, and I'll read it to you. It's in 163.3213 for the Florida statutes. It means an ordinance enacted by a local governing body for the regulation of any aspects of development, including a subdivision, building construction, landscaping, tree protection, sign regulation, or, again, any other regulation concerning the development of land. So everything we've been talking about, who has power to do it, this engineering review falls under this definition of land development regulation. It has agreed tonight and in writing previously, it doesn't have land development regulatory authority. So why are we still having this conversation? They're saying, city, give us that authority. I have a longer presentation I'm going to walk you through because this is very important for the city. Not just on this issue tonight, these projects tonight, long term, this has important ramifications for the city, the residents, and the taxpayers out here. Vice Mayor asked a question for Mr. Bain to explain the liability. What does that mean? Yes, the city has the authority to enter into an interlocal agreement. We already have one on the table. We're going to talk about more tonight. That's with city. The liability portion for the city and the residents comes not because CID has assumed that responsibility. It's if an engineering issue is missed, or something isn't done correctly, or something has an issue in the future. Although CID will be responsible for it, the taxpayer resident will pay for that mistake. Whereas up front, while it's in the city's hands, it's in the city's box to review that permit, to review that application, to verify that this is all being done correctly. That's a better place to leave that review. That's on the developer's nickel. That is not on the taxpayer's dime. That's why this issue is so important and so critical that the city engineer be allowed to review and verify that. That is crystal clear in the county's current ULDC. I'm going to walk you through all the documents we've talked about and the ones we've ignored tonight to show you where the city has that authority. Contrary to all the suggestions here that the city has no authority to review land development, that's just simply not true. It's not a correct statement of the law. It's not a correct statement of all the documents. They've been provided to you. I will give you more detailed analysis on them. Another question was brought up about would legal be allowed to review this for the city engineer. The last email from Attorney Dickendiffer in response to the city engineer's comments, is there a legal document showing that this positive legal outfall on someone else's property not owned by the applicant developer, is that legal, is it binding, where is the agreement? The response was, you shouldn't even comment on that, and your city attorney shouldn't look at that. Why not? That's our role. Before these applications, projects are brought forward to this city council, for you to make sound judgment and decisions, you have your staff to review it and say, check, 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 all the boxes have been checked. Yes, we've reviewed it for that. Yes, that legal document is there. Yes, that drainage is going to stay there. It's not going to go away if someone sells that adjacent parcel or if the property owners have a dispute. Is there a legal binding document on the record to accommodate that runoff? Again, if those things aren't in place, the problem of that flooding in the future falls on the taxpayer residents through CID, fixing it if it's broken. Again, I told you at the last meeting, no one's saying that's anyone's intent. No one's saying CID or their engineer is going to try to do something wrong. That is not the point. That's never been the point. It's where those checks and balances for the protection of the residents and the public to make sure it's done correctly so it doesn't become our cost burden in the future. That's what we're addressing, the bottom line of all of this. Again, previously we had heard it was about the cost. Tonight, not really. Not so much the cost. So what are we talking about? It's that review to make sure it's done correctly and whether the city will have any say in that process or not. Where does the non-duplication of services apply was another question. Again, we're going to walk through it. It's been explained to you before. If the city were trying to create its own utility department, I would tell you, you can't. That is ultra-virus. That would be wrong. The city reviewing these applications, it's not against the law. It's not ultra-virus. It's not something that's not within the city's purview. It clearly is within the city's purview. It is constantly said, those are going to be our facilities. Listen to what you're told. Going to be. That's at some point in the future. Again, what we're dealing with right now is whose responsibility is it to put it in the ground, to do it correctly. That's the city's responsibility. That isn't CID. Yes, they review it. Yes, they give us the letter. saying we have capacity, we can serve this project when it's built and complete. But that's the city's responsibility to issue that land development permit. That is not CID's responsibility. It's not even their authority. They don't have that authority. That's one of the things you didn't hear tonight. But I'm going to show you where it's clear. CID doesn't have the authority they're asking you to give them. They can't do what they're asking you for. It's clearly stated in all the documents. I want to make sure I've gotten the questions that were raised. I don't have a PowerPoint presentation for you guys this evening, but I do have the legal memorandum that was provided to all of the council, city manager, as well as to outside counsel. Not outside counsel, sorry, Lewis, Long, and Walker's counsel. It is very long, and there's a reason for that length. There were several documents, several items that needed to be walked through in more detail for the council and for the public. This isn't in your packet, so I'm going to take my time and I'm going to read through this. And I apologize for it, but it's important, and the public needs to know the documents that are on the table and why this is still an issue. This memo was to be a supplement to all the other PowerPoint presentations that have been provided to this council, as well as all the different letters, opinions, and PowerPoint presentations that have been provided to the council by Lewis, Longman, and Walker. There's two questions that I've raised that are for the city council to decide. The first is whether or not the city has authority over land development regulations. That answer is an absolute yes. Lewis, Long, and Walker has agreed. That answer is yes. I'm going to show you where that authority comes from. The second question is whether or not the city is precluded from creation and implementation of land development regulations by provisions contained in the city charter, the interlocal agreement, or the enabling act for CID. And the answer to that question is no. You've been told tonight that we're precluded because of that conflict provision. We are not. And I'll show you the other provisions in the document that say the city is not precluded from that. The document within them specifically acknowledges that it has no powers regarding planning or zoning, and specifically acknowledges that Westlake has the exclusive authority to set requirements with regard to land use regulations. The Enabling Act of CID provides that CID is subject to and subservient to the county's ULDC. The county's ULDC provides for review criteria by the county engineer, which is now the city engineer, with regard to any planned development prior to the commencement of construction, including requirements for stormwater. You were provided copies previously of that ULDC. You all have the charter, and you have copies of the interlocal agreement. The language in the charter. I'm going to read the provisions from the charter in the record. The first is section 4. The city has all powers unless prohibited by law or this charter. You've been told we're prohibited. That's not what these documents state. The city shall have all governmental, corporate, and proprietary powers necessary to enable it to conduct municipal government, perform municipal functions, and render municipal services, and may exercise any power for municipal services unless expressly prohibited by law. The powers of the city shall be liberally construed in favor of the city. That means unless there's an express prohibition, the city has that power. There's additional language in here about section 12. a transition schedule, deals with the comprehensive plan and land development regulations. Until such time as the city adopts a comprehensive plan, the applicable provisions of the comprehensive plan of Palm Beach County as the same exists on the day the city commences corporate existence shall remain in effect as the city's transitional comprehensive plan. However, all planning functions, duties, and authority to administer shall, we talked about the word shall on numerous occasions, thereafter be vested in the city council of Westlake, which shall be deemed a local planning agency until the county establishes a separate council establishes separate planning agencies. Nothing in this charter will divest any landowner in the city of development rights under existing zoning and land use approvals. All powers and duties of the planning commission, zoning authority, and any boards of adjustment and the county commission of Palm Beach County as set forth in these transitional zoning and land use regulations shall vest in the city council until such time as the city council delegates all or a portion of the authority to another entity. Subsequent to the commencement of the city's corporate existence, no amendment to the comprehensive plan or land development regulations enacted by Palm Beach County Commission shall be deemed as amendment of the city's transitional comprehensive plan or land development regulations or otherwise take effect in the city within the corporate limits unless approved by the city council. The code at the time of the city's incorporation locked in place. You've heard lots of discussion about that city's interim code. That's what we operate under. That's what Suzanne was telling you this evening. She has to apply that code. The language above states that all planning functions, duties, and authority to administer shall thereafter be vested in the city council. There's no ambiguity in that language. That language is clear. Who has the authority for these decisions that we've been discussing for months? The city is vested with that authority. Language says shall and not may. It does not provide an option for that power to vest instead. The Palm Beach County Uniform Land Development Regulations apply until the city adopts its own. Then we move on to Section 13 of the Charter, Seminole Improvement District Continuation and Transfer. The Seminole Improvement District, an independent special district created by special act of the legislature, shall become a dependent district of the city of Westlake on the earlier to occur of 30 years after the effective date of this charter or the date mutually agreed by the city and the district, which is the transition date. All special acts of the Seminole Improvement District shall become ordinances of the city of Westlake on the transition date. Then the next provision that we keep hearing about as the preemption says non-duplication of services. The city shall not exercise any function or provide any service being performed by or provided by the Seminole Improvement District at any time prior to the transition date. This section does not impair the ability of the city to contract for fire rescue or law enforcement services as provided in Section 13A and 13B above. The important words in that section, it is the city's power, unless it's specific power of city, then the city shall not duplicate. The question is, what is the service or function that's being performed by city? What's the service? What's the function? There cannot be a duplication of a service or a function if it does not have that authority. The services and functions we've been discussing are land development permits by the city engineer. I'm not making anything up. I'm not adding to that list. I'm not adding to that definition. I'm not putting something underneath there to give the city more power or authority. The statute defines this. I didn't make up that definition. Our charter defines it. I didn't make this up. It's a service or a function. It does not provide that service, nor does it provide that function. Therefore, there is no duplication of a service, nor is there a duplication of a function. Then you move on to SID's Enabling Act, which you've heard absolutely nothing about. That document is important, as they beat this horse to death about how important the city's charter is and how you have to honor everything in that charter. Their Enabling Act is their charter. It's the equivalent of their charter. It does the same thing. It gives them their powers. It gives them their authority. What does that document say? This Enabling Act, Chapter 2031, provides 24 powers to cities. Of those 24 powers granted by the legislature to cities, not one of them grants CID the power over land development regulations. To the contrary, there's a specific provision in there that is very important. Paragraph section 5.2 makes it clear that CID is subject to and shall comply with the land development regulations of the county, which is now the city. It reads as follows: notwithstanding any authority contained within this section, the development, operation, or maintenance of any district facilities or services shall, you get that word again, shall comply with the adoptive comprehensive plan for Palm Beach County and any adopted land development regulations or specialized plans adopted thereunder, which apply within the geographic boundaries of the district. It does not sit on top of the city. It does not sit on top of the county. They're asking you to allow them to do that. Take our certification. That's not what their own charter says. It doesn't say that. It tells it you have the right to do all these things, but you have to comply with Palm Beach County codes as you do it. What have we been talking about? We're asking them to comply with Palm Beach County code, which says give these documents to the city engineer with your application. Let her review it and make sure it's correct. And what is the response? No, we're not giving it to you. Why? We don't want to. Charter says it's a duplication of service. Not if you can't provide that service. There's no duplication. This is what we've been arguing about. Nowhere in CID's Enabling Act has CID been given planning, zoning, or land use authority for anything. Specifically, stated in Section 5.2 of the Enabling Act, the comprehensive plan and land development regulations are simply outside of their powers. Then you move on to the interlocal agreement. You've heard about the interlocal agreement as another stop measure where the city cannot review land development permits. That's not what these documents say. I'm going to walk you through that language.
Pam, if I may ask, who authored the interlocal agreement?
Myself and Mr. Dissenderfer worked on that interlocal agreement together. Mr. Bain was there as well as Catherine was a part of those conversations. We worked on that language together. The second argument which has been raised is based upon the interlocal agreement, that the city does not have the authority over issuance of land development permits and review of stormwater data and calculations because it's a duplication of a service or function being provided by CID. To the best of my knowledge, all the development that was here when the city was incorporated, CID has never issued a land development permit for building construction. The permits for the vertical structures that were out here were issued through the county. Palm Beach County was the entity responsible for issuance of land development permits prior to the city's incorporation. Once the city incorporated, as seen by the above charter language, the responsibility passed on to the city. The interlocal agreement in several places recognized the city's exclusive authority over issuance of permits all comprehensive planning, zoning, and land development activities. The best section for this is 18P and 18F. I'm going to read those provisions as well. Westlake has the exclusive authority to set requirements and standards for, approve, and issue permits or authorization for all comprehensive planning, zoning, and land development activities not falling within CID's area of authority as set forth above. Applicants applying for permits or authorization under Westlake's authority shall apply directly to Westlake for such permits or authorization. Westlake shall provide to CID notice of permits for projects at which utility meters will need to be installed prior to being issued a certificate of occupancy. Westlake shall not approve any action which would violate any South Florida Water Management District water use permit, South Florida Water Management District environmental resource permit, or the United States Army Corps of Engineers Clean Water Act permit issued to CID. Again, we stated previously when having these conversations, the city does cooperate and work with CID, has since the beginning, to raise those questions before development orders are issued, approving construction, to say when this construction is complete, will you have sufficient water sewer capacity to serve this project? And we've gotten those letters. There's one in your packet tonight from CID saying, yes, we have sufficient water and sewer capacity to approve this project. Therefore, City of Westlake, you can issue that development permit. You're not going to have a structure that doesn't have water and sewer to serve it once it's done. That's the roles we were supposed to play. That's the cooperation we were supposed to have. But there are two different permits. One is the city, one is the CID. The city's permit is for what the city does under land development regulations. The CID's permit is to make sure it's the right pipe size and that it's going to be constructed timely on their side, and whatever other reviews they have. We don't get in CID's box. I don't like the CID to get out of the city's box. The second paragraph, section 18F, says each party shall only review those items or matters over which it has jurisdiction, and no party shall deny a permit or authorization on grounds over which it has no jurisdiction. This provision specifically states Westlake has the exclusive authority to set requirements. In adopting our Chapter 5, that's what we've attempted to do. And at every term, we've been told we don't like them. We want to control them. The city has the exclusive authority to set those requirements and standards for, to approve, and issue permits or authorizations for all comprehensive planning, zoning, and land development activities. Section 18F specifically confirms that CID does not have the authority over these issues. These provisions are consistent with the language found in the Enabling Act and the interlocal agreement. The exception CID attempts to make is a carve-out for not falling within CID's area of authority as set forth above. This carve-out does not relate to land development regulations. Land development regulation authority remains power solely vested in the city. There's a section B that says CID shall have the exclusive authority to set requirements and standards for review, approve, and issue permits for facilities depicted in its water control plan, addressed in sections 9 through 12 above. Applicants applying for permits under CID's authority described above shall apply directly to CID for such permits. CID shall provide notice to Westlake of each final permit issued by CID, including amendments thereto. The authority covered in Section 9 addresses parks. Section 12 deals with water issues. Section 13 deals with irrigation, water services. Section 15 deals with surface water management and drainage. Section 14 is a restatement of the Enabling Act regarding construction of roads that are necessary and convenient for the exercise of powers. Nothing in this section gives cities any input on land development regulations. It's just not there. The power to create and implement land development regulations remains with the city. You have another section in the interlocal agreement, section 32A, and it reads, CID's powers. CID acknowledges that it does not have planning or zoning authority, home rule, or general police powers, and nothing in this agreement shall be read or interpreted to mean otherwise. That's not what you heard tonight. They're asking you to look at other provisions in this agreement and say, CID has that power. Consider your preemption. You don't have that power. That's just not what the documents before you say. Not what the documents we agreed to provide for.
Who wrote the CID powers? Who authored them?
The first draft of this came from the citizen effort. And we went back and forth on several of the provisions and sections within documents. It was a back and forth between.
So there was an initial conversation between city attorney as well as CID when it came to the document, right?
Yes.
And who authored city charter?
That was done by the law firm of Lewis, Long and Walker.
And who was included in that conversation?
I'm not sure who all was party to that. That was prior to the cities and corporations. Prior to me getting involved, the comment was, did I get to see that before the city incorporated? The answer is yes. There were several documents were provided to me prior to, but there was no changes to be made to those documents. The documents were what they were.
So I really appreciate the presentation. I do have a question though. What is your response? Because what is your response to Attorney Booker was with us from the beginning? What is your response to that?
I was not with them, whoever them is at the beginning. Was I given documents to review upon being asked about being city attorney in this project? Yes, I was. I had nothing to do with the drafting of all of those documents. That was prior to my time.
But you did review the document prior to making the commitment to be city attorney?
Yes. Again, continuing with the conversation, first section 5.2 of the Enabling Act, it was not performing planning, zoning, or land development functions. Those were by Enabling Act functions of the county, which have now been taken over by the city. I reiterate, it never had planning and zoning authority, thus cannot continue performing those functions. It was and shall remain subservient to the agency that is vested with those functions. That was Palm Beach County, now it's the city of Westlake. It's you all sitting here as city council members. Section 6 of the interlocal agreement has language that mirrors the provisions expressed in the preceding paragraph. But a specific note should be made. There's no limitation on the powers. Again, it states, nothing in this agreement shall be construed to restrict Westlake's home rule powers, police powers, or Westlake's authority to amend its comprehensive plan and make planning, zoning, and other land use decisions. That language appears several times throughout this document. There shall be no limitation on your ability to serve as a typical city. CID and the city cannot expand its powers beyond the powers given to it by the Enabling Act. CID was established by the state of Florida, and its powers derive from those specifically given to it by the state of Florida. Any changes to those powers must be given or taken away by the state of Florida. CID's argument that the city is prohibited from implementing land use regulations is in direct contravention of these provisions. CID is attempting to restrict the city's land use decisions by usurping the authority currently provided by Palm Beach County ULDC, Article 11, and replacing it with an acceptance letter from SID. This argument goes even further, arguing that the city engineer should not even review and comment on these matters. The city engineer's review, comment, approval, or denial of an application as part of the land use decision-making process. That's why local governments exist, to review these applications. Any attempt by SID to restrict the engineer's review in the decision-making process is contrary to the express provisions contained within the interlocal agreement. SID's next round of comments is that Section 16B of the interlocal agreement is a default provision for SID to be given authority over activity or permit review for drainage. Section 16 of the interlocal agreement requires consultation for items for which both parties want to undertake. That's been raised this evening. Vice Mayor, you raised a question about that. A project isn't one of the matters that we're talking about. So the term we're looking at is an activity. I'll read Section 16B for the record. In the event both parties wish to undertake the same or a substantially similar project or activity, it shall be given the right to undertake that project or activity. Provided, however, it must commence substantial work on the project or activity within 18 months of the semi-annual consultation meeting where the item was discussed, or within such other time as agreed by the parties. Alternatively, the parties may agree to jointly undertake a project or activity so long as the execution of the project or activity does not violate the law, the charter, the enabling act, or this agreement. The activity is a review of drainage data and analysis by the city engineer and the issuance of a land development permit. As previously articulated, it does not have authority for this activity. Upon review of Section 15 of the interlocal agreement, it has exclusive power to construct, to operate, and to maintain canals, ditches, drains, levees, lakes, ponds, and other works for surface water management. What this provision does not state, it does not grant SID exclusive authority to review nor approve. Those words aren't found in that provision at all. What are we talking about? Review and approval. Do those words appear here? No, they don't. The city is not attempting to construct, operate, nor maintain any canals, ditches, or drains. The city is carrying out its responsibilities with the city's charter, the interlocal agreement, its enabling act, and the Palm Beach County Uniform Land Development Code acknowledge our powers which belong to the city. It simply does not have land use or zoning jurisdiction. And the final one tonight is to look at what's in the Palm Beach County's Uniform Land Development Code, Article 11, that you've also heard about. Article 11 of the Palm Beach County's Code, as it existed on the day the city incorporated, which is the city's current code applicable to these permits and applications that are pending, has a purpose and intent section. It contains the following language. Implement a plan with respect to the installation of on-site improvements for new development, which improvements are necessary to meet or maintain the level of service required under the concurrency management system of the plan. Ensure provisions of safe, convenient, legal, and physical access to circulation among lots for vehicular and pedestrian traffic. Those were some of the items you heard from the engineers at a prior meeting. Ensure provisions of adequate utilities to support development of each lot. Regulate the subdivision and associated development of land subject to seasonal or periodic flooding, and provide for adequate stormwater management to minimize adverse impacts of the development on water resources while ensuring acceptable levels of protection from inundation for residents and improvement. Again, the engineer stated previously, it was to make sure there was no flooding and to protect property so that it's not damaged out here in the city of Westlake. Another one of those objectives, purpose, and intent is to ensure that citizens and taxpayers of Palm Beach County will not have to bear the costs resulting from haphazard subdivision of land or failure by the developer to provide adequate and necessary physical improvement of lasting quality. Ensure the purchasers of land in a subdivision that necessary infrastructure improvements have been provided in accordance with Palm Beach County standards for design and construction, and that associated rights and obligations have been established for the use and maintenance of said improvements. Article 11 is a very long section, but there's two sections in there that I pulled out to point out to you, to show you that the items we've been discussing for the past couple of months are contained within Article 11. Section 4E contains requirements for final stormwater management plan. It states, technical compliance applications shall include a final stormwater management plan detailing the design of all secondary and tertiary stormwater management facilities, including, as a minimum, the following design data and information. The list includes evidence of existing access to legal positive outfall, complete hydraulic and hydrologic calculations for design of storm sewers, detention areas, and discharge structures, identification of standard methods and/or proprietary models used for hydrologic and hydraulic analysis, a listing of specific requirements used as the design basis for street drainage, lot grading, finished floor elevations, floodplain storage compensation, reduction, detention volume, and discharge limits. That's a lot of engineering stuff, but that's all engineering stuff that you heard previously from the engineers, what information was being requested, why it was being requested, where it came from. It's in the code, required. Not something that's not normal or typical for site development permits. That's the data that the engineer was asking for. Chapter E, required improvements, section 4. Stormwater management also contains criteria for minimum required improvements for all developments to implement standards for stormwater drainage, runoff rates, legal positive outfall, and allowable discharge of stormwater runoff from each development to prevent flooding on adjacent lands and provide a basis for hydrologic data and design of stormwater management facilities. All of the aforementioned requirements are the responsibility of the county engineer, which is now your city engineer. It is not referenced in Article 11 of the ULDC. It cannot insert itself into a process which it has no authority to be part of. Its Enabling Act makes it subservient to the city with regard to land development regulations. The interlocal agreement makes it clear that the city and not city is vested with land development authority. Those are my comments for this evening. It's lengthy, but there's a lot of documents and a lot of information, and I'll be happy to answer any questions.
Seems to be clear. Both sides here.
I assume you have a.
Yeah, I don't know if you have questions for the attorney. I'd be happy to wait, but I do have a couple of just very brief points I'd like to make, if I could. No. I'll show you that brief. One is, the attorney's making a lot of hay out of the existing county ULDC. As I said earlier, there's a reason the city was created. It was created because anybody who works in land development knows that trying to accomplish anything in Palm Beach County is a nightmare. That's what the city was, the whole goal, the whole shining point of this was let's create a city that's efficient, that's nimble, that relies on its professionals. That's what we're here to do. That's what we're looking to do, and I think that's what your engineers are trying to do in their guide. Your attorney said a lot of things there, and she buried part of the interlocal, which, as she said, she had a hand in helping draft the interlocal agreement. Maybe not the charter, but the interlocal. And she read this paragraph and was in the middle of a lot of things, so I'm going to read it again right now. SID shall have the exclusive authority to set requirements and standards for review, approve, and issue permits for the facilities depicted in the water control plan, which is the stormwater system, and addressed in 9, 12, and 15, which, as she said, is water, wastewater, irrigation, roadway. She then read a section later that talks about SID's role in those things and says they're not permitted. But she had already read to you, SID permits those things, has exclusive authority. And as we talked about in your charter, there's non-duplication of services. SID has the authorization. The interlocal recognizes it. The charter recognizes that when SID does it, the city doesn't get to do it. All this other stuff about calling it an LDR, and as she said, in the county, you have to provide evidence of LPO. And to get a land development permit in the county, I'm sure the regulations say, you've got to provide evidence you've met the stormwater requirements of the city. And you'll get that evidence. It'll be certified by our engineer, a local government body charged with stormwater control, operation, permitting, setting standards for it within your city. That's what we do. It's what we've always done. That's what we'll continue to do. It's what we have to do. And so we're going to continue doing it. And we would ask you to, recognize that authority. When there's an issue with the stormwater, you come to SID. That's what we're paid to do. That's what your assessments accomplish, what your regulations and our regulations accomplish, and that's our role. Thank you.
Either one of you. Pam, you mentioned, if you could come back.
Yes.
Pam, you mentioned land development and zoning authority. But if I'm clear, is that included in this? I heard you mention land. I thought we were dealing with the stormwater.
We are dealing with the stormwater information. The question is, what's required when an applicant comes in and submits a packet with documentation? What do they have to give to the city to get that permit? The code says to submit that and go through vertical construction. That's called a land development permit. What SID is trying to say is there's carve out for drainage, roads, water, and sewer. City, you shouldn't look at any of that. That's not land development. That's reserved exclusively for SID. And as I've walked through, that's not what the documents say.
That's exactly what the document says.
Can you repeat that line again about exclusive authority?
Yeah, and she had begun, this is section 18, paragraph B, and she went on to C, which, again, you got to understand, this is the order. After it talks about, in the interlocal agreement, after it talks about Westlake has the standards for planning, zoning, land development. Yes, all of that. Prior to that, paragraph B, SID.
This is still the interlocal.
Interlocal, 18B. SID shall have the exclusive authority to set requirements and standards for review, approve, and issue permits for the facilities. One, depicted in the water control plan, which is like we talked about, it's our constitution, provides all of our systems, and addressed in sections 9 and 12 through 15 above. As Pam walked you through, that's water, that's wastewater, that's irrigation, that's roadways, that's stormwater. Applicants applying for permits under SID's authority described above shall apply directly to SID for such permit. SID shall provide notice to Westlake of each final permit issued by SID, including amendments thereto, and closeout of such permits. You're in a local. You have to come to SID for a permit. We review it, we approve it, we issue the permit, and ultimately, we own it, we operate it. So once that happens, some of these nightmare scenarios we talked about, what if something goes wrong? What if SID stops working at it? city's on the hook, it's our system. If somebody's getting flooded, and it's our responsibility to flood you, the city has no authority to do anything about it. What are you going to do? Come and start ripping out city's facilities? No. We own them. You can come in and do it, we're not doing it. Well, we're doing it. You come to our petition our government. We have a board. We're elected by the landowners. We have a manager. We have an engineer. Why is our road flooding? Absolutely. We're the person you're going to come to. That's why we're set up this way. We're here, we're functioning. We have 2 engineers that agreed on the standards. We're going to review it and permit it. We're going to make sure it's built right. We're going to own it. If there's a problem with it, it's going to have to come to us.
At the time this interlocal agreement was put together, who was the governing board of SID? Who was on that governing board?
I think Mr. Massey was on it. I think Jared Stern was on at that time. I can't remember the other lady that was on.
Were they landowners here? Or what involvement did they have at the time?
They were appointed by the landowners in the landowner elections.
And you were mayor at the time?
That would have been Minto then.
Minto is the primary landowner, which has the most votes.
And as the board sits now, we have 2, Mr. Massey, and 2 board members that are Minto employees. Is that correct?
That is correct.
So that was made up of. So the interlocal agreement wasn't made with Minto employees as the governance.
I believe Mr. Stern was a Minto employee, and I believe the other lady was also a Minto employee. Minto, as with any 298 district, which is landowner, whoever the majority landowner or whoever controls the majority of the proxies appoints whoever they believe is appropriate, actually elects them in a landowner election. So they have one every year because they stagger them every 3-year term.
I asked you this question today, as a matter of fact. Any legal fees that some improvement district has are then passed on to taxpayers, which would be the residents also, the same way as our city taxes would be.
Same as it's in the assessments and it's in the ratepayers, landowners, whoever they are, whether they're individual property owners of small properties or large property owners.
Do you off the top of your head know what the legal fees for some improvement district were last year?
Hold on a second, I do have that. Last year's legal fees, actually it's for the 2020 year. Legal services were $552,416, and that work included a challenge to the water plan, plats developments, ITID lawsuit, school board issues, Chapter 5 LDRs, and work with FDL.
So the largest portion was paid by the land developer.
Yes, whoever owns the most land gets whacked the hardest. Correct.
Except for a lot of it's agricultural, so it's not get it started?
No, they'll get charged by acres. It doesn't matter
There's
whether
no-
it's ag or other. It's in the assessment methodology. It's by acres, by the land. So
Because the taxpayers need to know that they're paying legal on both sides, for the city and by some of the with the district.
And I agree with you more. As a taxpayer.
Yeah.
I cannot agree with you more.
Just want to make it obvious. That's all. Did you have more questions?
Can I make one really quick point? Really quick. So in listening to everything going back and forth, there seems to be a little bit of this talking back, okay? So land development power, land use power, it doesn't have it, city does, check. We are all in. So take that a bit further. Land development permit, is that a function of land use power? Yes, check. So it's not arguing that. But the function and issue isn't the issuance of the permit. City does that. I think the examples show you that it's who provides information and certification of meeting certain standards to tell you, the city, that you should issue a permit. Let me give you an example. The fire department, Palm Beach County Fire Department, does not have land use authority in City of Westlake. However, we can't get a land development permit unless we prove to them that they can get their turnarounds in our cul-de-sacs and blah, blah, blah. They set those standards. They let the city know that those standards are okay. That letter serves as a check to get the land development permit. So I don't think we're saying different things, just we're reading the words very differently. I just wanted to point that out and give that example because I think it's very similar to what we're talking about here. So what we're at issue here is who provides the drainage service, the road building service. So not the issuance of permit. That's in the city camp. Who's telling you that the standards for those facilities are in the control and jurisdiction of whoever needs it? So I just want to give that example.
Again, we talked about this a little bit previously. The fire district does get to review those plans and say they meet fire standards. Excerpts, copies of that not pulled out and given to the fire district. The entire set of plans are given to the fire district. The fire district does not accept certification from the development engineer to say, hey, you meet your fire code. Don't ask us any more questions. The engineers being asked to take the certification instead of doing their own job, their own due diligence, their own review for the protection of the public, the residents. Fire reviews that for the protection of the public. It's no different than what's being done here. That's how you're looking at this. Should the city be excluded from that review? My answer is no. Is fire excluded from their review? No. It's part of the process. You do it everywhere else. Submit the data and analysis for the city engineer to review, to do her job for the protection of this council, the residents, and the public. That we've met that criteria. The city chooses to review all of that as well because of whatever their guidelines. That's great. And the residents are super protected. But it does not mean the city should be precluded from doing its review and its job to make sure our residents are safe and the businesses out here are safe. Those are the questions for this council to make a decision on this evening. I think you've had more than enough information from all sides on this issue. It's been talked about at great length, and you have from Mr. Gissendecker, and I would certainly concur with him that decisions need to be made this evening so that we, the attorneys, are not still hashing this out, so that any applicants are not still uncertain as to who does what. Another commentary is, I saw emails going back and forth this afternoon from the engineers, but the attorneys have not reviewed any of the language that they're saying they have agreed to. So as we get ready to draft this chapter 5, there may still be further discussion and debate about every little place where it is, where the city is, and who does what. So I would hope that this is the end of it, but again, keep in mind, not gone back through what that specific ordinance for the city will look like.
I just have one question. In one of your comments, I'm going to turn to that, you said something about if there's a mistake or whatever, the taxpayers, what happens if the city misses something in its review and there's a mistake and an error down the road? Who's on the hook?
There's one more area of discussion. The city engineer doesn't have that liability if someone else is designing.
I understand that, but isn't it the same thing? Aren't the taxpayers on the hook? If the city misses it in its review and there's an error or mistake, it's the same thing as if SID misses it on its review? Is it not the same?
No, I do not believe it's the same thing. There's one more point where we've had a disagreement, is there's a 1-year maintenance bond that would be required. If the developer builds the stuff, they give us the bond. Started this discussion, we talked about that, to make sure it's done right. At the end of that, there's a 1-year maintenance bond that the current proposed code requires, county code, other jurisdictions code all require. You may not notice the deficiency immediately. As you're doing your inspection, they're done and they turn this over. So there was an additional year time frame given to make sure if there were mistakes or if something went wrong, you have that insurance guarantee to go back and fix it and repair it. I haven't done the analysis to say what's the probability that something will go wrong after that year, so I don't know. If that meets the codes and the engineers have reviewed it and signed off on it, I'm assuming if the site is flooding or there's damage, the property owner is going to address that for themselves. If SID wants to take on that responsibility and go add drainage or fix it or repair it or do something else, once it's been turned over and maintained by them, then they can certainly do that. But again, there's a question of timing. At the time of the application, it's the city. 1 year after that, currently recommended and drafted, you will have a 1-year insurance policy in place. After that, SID owns it. Turned over to SID at the end of that maintenance period, and so if something else is wrong with it, it will repair and maintain it. Again, that's what the interlocal says. It gives them that maintenance responsibility for that drainage system. It gives them that responsibility for the water and sewer lines. That's where, in my mind, the bright line is for whose role is it and at what point in time. Up until it is turned over to SID, it's the city's responsibility. Once it's turned over to SID, it is no longer the city's responsibility because they are an entity charged with maintaining all of those facilities once it's in their hands. What we're talking about now, these applications, it doesn't belong to SID. They don't own it. They're not responsible for maintaining it. That's the city's job.
Any other further questions? Well, we've come to the 11th hour.
One way or another, let's put this together. As a board, do we all give our opinions now? Do we? I don't know. Like, do we talk amongst ourselves about it?
Somebody can make a motion and second it and then discuss it.
Are we ready? Let's go ahead and make a motion and vote is how it votes. All right. I want to make a motion for a Seminole Improvement District to be responsible for performing our stormwater review as outlined by our 2 engineers.
I will second that motion.
Discussion.
For me, that the silver bullet is that exclusive line in the interlocal agreement. It is so black and white. It is so clear. And it even says set standards and reviews. Exclusive. To me, that kind of ends the discussion right there. But, you know, you brought up a wonderful point about taxpayer expense. And that cannot be ignored. For me, $5 extra of taxpayers' expense is $5 too much. And I say that as an actual taxpayer here in Westlake. So, you know, I think it's pretty clear.
For me, you know, I am one of those, if it's not documented, it didn't happen. And authority would you approve the language to me. It's clear in that, and we do have residents who the taxes are high for them. And we need to be able to move forward with development here in the city. And what I would not want to do is see people go in foreclosure as a result of taxes and things of that nature. So here's the thing, that's just me, right? And this is up for discussion. I think that another thing for me is people were at the table when this was initially being said and done. And so that's a concern for me. If people were all at the table at the same time, then I do have a concern that we are 5 years in. We are literally 5 years in. And so we need to go ahead and make a decision on this. Another thing is, I feel as though because of this, the uncertainty of us not making a decision, it has created a culture within the city as it relates to staff that we need to go ahead and make sure if everyone knows exactly what their role is, we can move forward. And that's just me. I'm just ready for us to be able to move forward. But like I say, that's just simply my opinion.
Sure, that's what we're here for.
Sure, sure.
Dr. Paul, Kira, whichever.
I'm just going to keep it brief, but I think it's very clear in the interlocal agreement. I agree with Patrick Paul, Katrina. Sorry, thank you.
Okay. Paul, do you have any comments?
None that would make any difference in the tonight, so no.
Okay. I still have a lot of, there's a lot of ambiguity here. I can see what the opposed opposition to our city attorney points, but I see the points that our city attorney makes. And I feel that our city attorney has done here and looking out for the well-being of us collectively as a city and doing the right thing. And I know that staff has been had same concerns that she has, and I can't go along with some improvement this on this one. So that's my comment. Okay, we have a first and second on the floor.
There being no further discussion, Mayor, I'll do a roll call vote. Motion made by Vice Mayor Long Robinson, seconded by Councilman O'Connor. Roll call vote. Councilman O'Connor?
Yes.
Vice Mayor Long Robinson?
Yes.
Mayor Manning?
No.
Councilman Paul?
No.
Councilwoman Crump?
Yes.
Motion carries 3-0, or 3-2, sorry.
do I understand the motion, and that puts back into effect the memo that I sent out on September 2nd with Sid doing the reviews, correct?
Here's the, what was the exact language in the motion for this year?
And, Sid be responsible for and perform all stormwater reviews as outlined by the city attorney, city engineer.
I would like to see, the language, if there's other language drafted by Sid and their governance, adopting any changes that were made, collectively between the city and the Sid engineer, so that we know that the path has been followed.
What you'll have on both sides of the equation is the exact documentation that's been approved by both legals, from city legal and from Sid legal, as presented to both boards, based upon the engineer's agreements. Once that language is worked out, both boards will get the same language at the same time.
So we'll get a technically the comprehensive document that they came up with together.
Yeah.
Okay. I'd like to find out, is it dangerous to vote on something like this before we actually have seen the final draft? So, we're just gonna take it quickly.
Little recess.
Council has recessed for 5 minutes.
I wish I haven't had dinner yet, and I was bored one. Okay, we're gonna move on with, public hearing. The final plot, the Westlake Plaza. Presentation.
Mr. Mayor, for the record, Donaldson Hearing here tonight on behalf of the applicant and Public Supermarkets. This is a plat for what we refer to as the west half of parcel G. The site plan is on the agenda following this item. The plat, of course, is simply creating a boundary for the property as required by state law. It has been reviewed by your professional team, including the city engineer and Seminole Improvement District and the city attorney, and has been found to be in compliance with all requirements of state law. Therefore, we would request your approval, and we look forward to, in a few minutes, talking to you about the Publix at Westlake Plaza, some of the first commercial development in the city. Thank you.
Thank you. All the technical stuff.
Do you think he's got his mic back? He might have kicked back on to create some feedback so to make sure.
So you can
Go to the bottom, see the 3 dots. Change audio. Disconnect audio.
Good.
Yeah, some of them, they trigger off, they stay off on the audio. Other pads, if it triggers off and you log back on, turns the audio back on and starts feedback.
I'm down to 3% here, so
Good.
you guys might lose me.
Okay, so that concludes the presentation on resolution 2020-32.
We can make a motion to approve.
I'm sorry, I need to read the resolution for the record.
Yep.
Resolution 2020-32, a resolution of the City Council for the City of Westlake, Florida, approving the final plat for the Westlake Plaza plat being a replat of portion of Tract M3, Persimmon Boulevard West, replat recorded in Plat Book 129, page 129 and 130 of the Public Records of Palm Beach County, Florida, and a portion of Section 1, Township 43 South, Range 40 East, City of Westlake, Palm Beach County, Florida, providing for recordation, providing for an effective date.
I make a motion to approve resolution 2020-32.
I'll second the motion.
I have a motion made by Councilman Paul, seconded by Councilwoman Crump. Roll call. Vice Mayor Long Robinson.
Yes.
Mayor Manning.
Yes.
Councilman Paul.
Yes.
Councilwoman Crump.
Yes.
Councilman O'Connor.
Yes.
Motion carries 5-0.
Public hearing B, master site plan for 5G Republic at Westlake Plaza.
Yes. Good evening, Mr. Mayor, council members, and Mr. Zacharias, Planning Director for the City of Westlake. I'm truly thrilled to make these presentations. We all have been waiting for a long time for a public plaza in our city. So I have a number of slides to break down what is this presentation about it. So please go to the next slide. So the master site plan of this public plaza is located on the south part of Part G and is 20.321 acres. Next, please. There is a number, there is not the top of this master site plan. I don't know, maybe you can see it all on your screen. The top part is very important. So the master site plan includes 5 parcels. Parcel A, that will be a fast food drive-through, 1.04 acres. Parcel B, 5,500 square feet bank, 1.05 acres. Parcel C is for a sit-down restaurant, 1.11 acres. Parcel D, 6.53 acres for retail. And parcel E, which is phase 1. That is the phase that the applicant is moving forward at this point. So parcel E includes the Publix itself, the Publix building, 48,367, which also includes a drive-through pharmacy and 1,400 square feet of a liquor store and 9,600 square feet of retail, office, or medical. So that's parcel E. The next slide, please. So through the review process, I did ask the applicant, okay, we know which is phase 1, which we just went through, and then I asked, what is the next phase after phase 1? So additional phases will be market-driven, basically. So each of these plans, when we have an applicant, there will be a review by staff and will be heard and approved by City Council. When Planning and Zoning and Engineering receives an application, we review for compliance with code, and then comes in front of council that can approve, deny, or approve with conditions. That's the applications in front of council. So next, please. So I just want to break it down what exactly is phase 1, which is our first phase. So phase 1 includes the public grocery store with a drive-through pharmacy. It also includes a liquor store and 9,600 square feet inline retail office medical building. It also includes, on this first phase, they are going to build the access ways to the plaza from Town Center Parkway and Persimmon Boulevard. So as you can see on the slide, there are 3 access ways. Next, please. Also, this first phase includes a sidewalk connecting to multimodal pathway. Basically, the pathway that we have fronting here on Seminole Pratt Whitney Road, that there will be a connection to the interior of the plaza. You see on the slide, that's number 3. That is the connecting multimodal pathway. So number 4, there will be also an interior plaza sidewalk. That will be part of the phase 1 too. And very important, there is also a concrete slip panel wall. So on the rear side of the public building, there will be a 6-foot buffer concrete slip wall panel that it will be built on phase 1 only on that specific area where it stops. Because the applicant, the remainder of the wall will be constructed with the future retail development on Parcel D. So whenever Parcel D is developed, that wall will continue. This slide, staff put together this slide to break down all what is included as part of this application. So, what is the purpose of that wall? Well, that wall is to become a buffer, what is on the other side, which is important also.
Is that for sound dampening, basically?
That complies with many requirements also. Visual, sound, and separation between different uses. So the next slide, please. So this application, this master site plan, actually I wanted to mention that you're gonna see 2 presentations. This is just the master site plan for the entire plaza. Then we are going to see the site plan review for the phase 1 only. So for the entire plaza, it was reviewed by the landscape architect. There are plantings placed around the perimeter of the building and throughout the parking lot according to requirements. So landscape buffers are proposed along the north, south, and west property boundaries. With regard to drainage for each out parcel is not presented at this time. Applicant is required to comply with drainage requirements at the time each parcel's development. So as we come through, like a phase 1, when we go to the presentation for phase 1, you will see there is a specific analysis that has with regard to drainage. So for the entire plaza, there is not an analysis with regard to that. So
where is that going to come into play? When was that analysis done? Who does the analysis?
So Suzanne, please.
Rich Enmore, again, the city engineer. So under the site plan application package, each out parcel would come in and they would just have to demonstrate that they have access to that stormwater system for their site. So right now, this is just an empty field. They can't really show what they're planning to do in the future. So when they come through for that specific parcel, they would show the drainage connection to the master system.
In the second presentation that you will see the phase 1, you will see a specific language with regard to drainage. This is just the overall master site plan.
Thank you.
Next, please. With regard to traffic, also the traffic engineer did an analysis and it was approved. The total trips projected for this application do not exceed the approved trips for Westlake per the development order. So there was quite an extensive review with regard to traffic to make sure, the last paragraph, that we do not exceed our development order. The next slide, please. So we also review what is the pervious area. Per code is required minimum 25%. So basically what the applicant did is to use part of the rural parkway easement to comply with the code. Just I want to make sure the city will monitor these percentages of the RPE to be applied toward the pervious area on future commercial plaza developments in terms of parcel A, B, C, and E. So basically, the rural parkway is part of the plat that belongs to this plaza. So they are using part of that to comply with the 25% of minimum pervious area. So they have a lot of concrete, a lot of parking area. So they were just 21.04%. So they are using part of the rural parkway. So as they develop the other parcels, I think they're gonna continue using that to comply with the code, which requires 25%. But we are going to be monitoring, so that's part of our review. Next, please. With regard to connectivity, I'm sure you can see the whole slide. I don't. Site access and connectivity. So this slide shows that there are 6 points of vehicular access or interior driveways. So there are 2 connecting sidewalks from the rural parkway easement to the plaza. You see the purple? They are connecting those to the plaza from the RPE. And then there is one interior plaza or one interior plaza sidewalk. That's number 1. So the next, please. So the applicant is proposing interior connecting sidewalk and interior street driveways as a concrete material. So they are concrete. So that's photos of different places just to show how this is gonna look. Next, please. This slide shows what is on the staff report. And then these are views of other plazas throughout Florida. In this case, it's Public Plaza at Alton. In that specific public plaza, the sidewalks, the interior sidewalks are decorative pavers. And also the interior streets or driveways are pavers, as shown on the photo. Next, please. This is another public plaza. It's a Frenchman's Crossing in Palm Beach Gardens, also showing that the interior sidewalks are pavers and not concrete. Next, please.
Are you suggesting that, or saying that pavers, there would be more decorative pavers in rather than having concrete over there?
No, what I am just presenting the facts. The fact is that Publix has provided, this is another one, more decorative pavers in another plazas, and what they are proposing here is concrete. So Publix, this is another plaza on Sandestin. In this case, they even provided a water fountain as a focal point. So the next, please. So this is in Del Rey, public market at Del Rey, and also just to show the interior sidewalks, they have pavers and they have trellis, and also the interior accessways, they have pavers. So these are examples throughout Florida that was part of the research that planning staff has conducted. Next, please. So this is the public market in Aventura Shopping Center. Again, the accessway with pavers, and then there are interior sidewalks also with pavers. Next, please. So this is just to clarify what exactly, as part of our review, city staff asked the applicant to propose aesthetic materials, pavers or others, on interior streets, driveways, and interior plaza sidewalks instead of concrete, as other public plazas throughout Florida. However, the applicant has confirmed that the proposed plaza in Westlake will have concrete. So, I mean, I'm just providing the facts. Next, please. So as part of the site design, and this is also just part of the staff report, designs and aesthetics are paramount to the vision and goals of the city of Westlake. This development will be the first new shopping plaza of the city's vibrant Seminole Pratt Whitney corridor and will set the standards and precedent for future commercial developments. Since the city of Westlake is positioned to become a dynamic center of the western surrounding communities, it is critical that the proposed public plaza be consistent with the city's vision and guiding principles. One of the city's guiding principles of the comprehensive plan specifically says, build city character and identity. The city will promote economic development and provide for attractive public spaces throughout the coordination of building architecture, site design, and streetscape improvements. That's part of our guiding principles that was brainstormed with the council in 2018. Next, please. So just to demonstrate an example, the existing decorative materials that are used connecting sidewalks at the Minto Sales Center facility that is right now, that is right now those are decorative pavers. Next, please. So I just also want to provide another fact. The applicant has applied for a master sign plan for the entire plaza and for phase 1 that will be heard by City Council in December. So that application for signage for the entire plaza is coming in front of Council in December. So the applicant is requesting 6 waivers that will need City Council approval at the time. Just wanted to provide you this fact. Next, please. So just to finish, this subject application was reviewed by city staff, planning and zoning, engineering, was reviewed by SID and the Palm Beach County Fire Rescue. Based on the facts, the Planning and Zoning Department recommends approval of the subject application with this condition. We are recommending that the vacant parcels A, B, C, and D, to keep the visual appearance, the subject parcels need to be maintained, regular mowing, and receive temporary watering by way of traditional water tracks. Basically, at this point, we have an empty field. Now, on the next presentation, you will see the applicant is proposing to build phase 1. So what's going to happen with all that other vacant? They need to keep up. They need to be aesthetically pleasing. So that was the condition that that I was proposing. Thank you.
Thank you. I do have a question.
Yes.
Got all these golf cart cowboys around here. Are there any? Not to reach here, but are there any provisions for golf carts as to where they can or cannot be? I'm thinking of scenarios where someone with a pickup truck overlooks a golf cart, backs up into them, and then something bad happens. It is supposed to be a golf cart friendly city. Are there any provisions where golf carts can park, where they can maneuver, and so on?
Well, the city council had approved an ordinance with regard to golf carts, and there are specific provisions that the width of the sidewalks was to be. So basically, inside the plaza, if there could be accommodation for golf carts. Don?
I have a question for this guy. I think Don needs to answer that.
Yes.
Don, the side, I guess where you're coming at, Councilman Paul, are the sidewalks coming off of Seminole Pratt and into the facility adequately sized for the 8 or 10 foot wide pathways that golf carts and people will be on as a multimodal path?
Again, for the record, Jonathan Herring here tonight on behalf of Public Supermarkets and Windcrest Development. The sidewalks on Seminole Pratt Whitney, the multimodal path, I believe that's 10 feet in width.
Right.
Also, multimodal paths are provided on the northern boundary, which is Town Center Parkway West, and also on the southern boundary, which is Persimmon. The sidewalks that come through the center of the site that Nielsen had pointed out on her PowerPoint that are in the center are intended to be more pedestrian oriented and not to accommodate golf carts there. We want pedestrians, but the golf carts certainly can come down any of the perimeters of the site and enter the site. As for specific golf cart parking, we have not designated any specific area on the site at this time. There's more than ample opportunity, in the event that there's substantial golf cart traffic that started to accumulate. We certainly could take any of the parking spaces. We exceed the city code as it relates to parking and create areas that would be designated for golf carts. Since we are on the opposite side of Seminole Pratt Whitney, I think at least in the early days here, we would propose not to try to overly encourage golf carts crossing Seminole Pratt Whitney to get to the public center.
Did that answer your question? First of all, did that answer your question?
To an extent, like I said, my concern is always safety. I don't have a golf cart, so we cannot.
Yeah.
Not so much my issue, but if there is a golf cart, I would like for these people to be, safe as possible.
Right.
So that's really my only concern.
Will they accommodate golf cart parking?
Oh, absolutely. We have more than
Designated.
They are not designated at this point. They are just regular parking spaces.
Right. At this point, our preference would be not to designate until we see a demonstrated need. Under your ordinance, I think somebody can park wherever in a vehicular car space, and that's absolutely fine. We have more than ample parking to provide that. If we see that there's a need and there's a lot of golf carts, we'll work with the city manager to designate that. I think we could agree to a condition of approval if we see a need and we have a problem that we would address it. But we don't want to start off the bat and encourage golf carts crossing, 6 lanes of Seminole Pratt Whitney to get to the facility because there's no residential located to the west at this time.
JP, do you have a comment on that?
Yeah, I have a few questions. One, the multimodal paths that do lead into the plaza, will there be off ramps to basically get into the regular where cars normally go?
Yes, sir. Yes, sir. We have a pedestrian connection that comes all the way through the site.
And it will be wide enough?
It is intended for pedestrians.
It's not for golf
We've
carts.
not designed that for golf carts.
He's talking off of Persimmon and off of Town Center.
Yeah, so off of the multimodal path.
For Persimmon, yes, it's wide enough.
Yeah,
Those are 10-foot sidewalks that come in on
the off ramp.
No.
Into the actual street. So you got to imagine, you're on a golf cart, you're using the multimodal path to get to public. Now, how do we get from the multimodal path onto the car lane?
Oh, real easy. The multimodal path basically has off ramps into the drive aisle. It gives you more than opportunity.
And you're wide enough for a golf cart?
More than wide enough for golf carts. Yes, sir.
How much is it?
I'm sorry, may I interrupt? I have too many people talking at once. For the record, can we please have one person speak at one time?
Yes, ma'am.
Thank you.
Second question, now that we have passed this golf cart ordinance, and that, I'm glad you actually brought this up, because this is something I want to talk about eventually, actually changing our code to require.
That's what I was going to tell. If from now on we're gonna be talking about this, we need to change our code and require, for example, we can say 15% of the total required parking needs to accommodate, for example, whatever percentage,
Agreed, but, we have passed this ordinance, we are now a very golf cart friendly city as we were built to be originally. And I think it would be remiss of me if I didn't mention that we should have some kind of designated spots. Not to mention, you can have a lot more golf cart spots instead of one golf cart taking up a whole cart spot. You can take 10 spots, for golf cart spots. You get way more than 10 golf carts. You got to look at the environmental impact. It's we want to be green, we want to be forward-thinking, innovative. I think it's definitely something to consider. And we just adopted this ordinance, so Ken will be able to get you the numbers on how many people register the golf carts, and you'll be able to see that there truly is a need.
And again, if we see the need, I mean, certainly Publix is in the business of making sure that their customers are well satisfied and that they are safe. We'll certainly, work with the city to make sure that that's accommodated.
Will there be any electric car spots?
I don't recall.
No.
We have, at this point, we've not provided any. Again, if we see the need, that's something that we would look at.
But I think it's so critical to amend our code to actually require those, because when we are doing the review, the code it has to be in our toolbox. So by the time it comes to council, those things will be taken care of.
Is that something we can put on a future agenda to discuss?
Yeah, we can look at our parking code, revise it to accommodate golf carts and electric charging stations or parking.
Excellent. Great. I have a couple questions for you though.
Yes, please.
So the 9,600, or for Don here, one, if you guys both can answer. So the 9,600 square feet, if I understand correctly, can be retail, office, or medical.
Right.
Yes.
Yeah. So the inline area is actually 11,000 square feet, of which 1,400 is the pharmacy.
Yes.
Yeah, it could be pretty much anything that you would see in a traditional shopping center.
So
medical,
it
could be
rules that tell us how much of each there might be.
No, there really isn't. You obviously have to have the proper amount of parking. We try to get a good mix in today's world of retailing. Obviously, everything has changed. The idea that you're going to have somebody selling fashion and fabrics is probably something that's less likely as a service like a dry cleaner or a dentist or a veterinarian. That the uses or an eye doctor, the types of uses that we see in most commercial shopping centers throughout the state.
I just want to make sure we have a healthy mixture of all of them. I hate to see 8 offices.
No, I don't think that you're going to see. It's fairly expensive space for professional office.
Okay.
So you will see, what I would say is almost the more retail-oriented medical type uses. So the eye doctor who's also selling eyeglasses, those things that you'll see. Right. Often you'll see a chiropractor, but it's all market-driven, and I hope it fills up right away because I'm sure that Publix and the development team wants to build the balance of the center out there, and we have a lot of opportunity. In total, will be 140,000 square feet, and as you can see, we're really starting out, just a little bit below 60,000 square feet. So we can provide for all of those things on the site.
One last question. When we talk about pervious area, just so I understand, it's
yes.
Green area, right? Green area?
Yeah, it's where the water will go.
Mm-hmm. Right. It is the pervious area.
Yeah.
And the
green area, yes. Grass, yes.
Grass and landscaping. So in concept, the code requires 25% of the site. And so we're talking about the entire site. The parcels are just something that we arbitrarily parceled out in order to define entitlement on the various pieces. So at the end of the day, the entire site has to meet that 25% requirement, and I'm certain we will.
When you say that you're using some of the multimodal paths to cover pervious, is that like the center? Is that
it's part of there's a 90-foot rural parkway, which is really the eastern buffer to the site. The rural parkway that's out there, right? 80-foot rural parkway that's out there. So not the multimodal path. That's one of the largest green areas of the site. And so, given the value of land, we have to look at it as a whole, not as an individual piece.
Thank you. I'm very excited about it.
You're very welcome. And
yes. So, any other questions?
Yes, I do.
Yes, please.
Well, I appreciate the conversation. And we talked about before incubator spaces. Mr. Herron, I know you've been dealing with Publix and Mr. Carter, but have there been any more conversations about incubator space? Because of course that costs the developer, right? And what we know is you're gonna want, or people are gonna wanna be able to eat. Or we're gonna want some type of restaurant eatery at the public plaza. When we see these plazas, we see eateries and things of that nature. So has there been any more discussion about incubator spacing?
Not on this parcel, since this is an application of the public supermarkets and their developer. So that's not proposed. That could happen on some of the other properties that are out here, but it's not proposed as a part of this. Certainly, they're good at what they do, and they'll, because they're public, and this will be a public-owned and operated center, they will attract some of the best operators and restaurants around.
But with regard to incubators, I think what is that we have discussed in the past is that the city needs a program. That's a program. That's not something related specifically with a specific application. That's a program.
Sure, but I know there are some developers, or when public comes, that can, as well as Mr. Carter, can start having those conversations. That may be something that we want to see, because that has been done in other municipalities. So I would like for Ken to at least have that conversation with Mr. Carter, so that maybe something like that can happen. Because you're gonna need eateries in these plazas.
Yeah, the program usually includes, for example, incentives. For example, other municipalities, they want to promote. They will waive certain fees, so that's a program that is a policy driven and needs to be approved by City Council.
Mr. Council to start having those conversations. Yes, absolutely.
I'm more concerned with the aesthetics. Publix does all kinds of different things everywhere they are. They conform to what the city asks them to do in order to build their stores. In fact, my dad was a builder back many years ago and built the first Publix plaza up in Port St. Lucie Boulevard. And they're a great company to work, to construct and do projects. But rather than seeing concrete out there, I'd rather see pavers and a more aesthetic look to it than concrete.
Right. And let me respond to that. And representatives from Publix corporate are certainly on the call, and certainly Tom Murray and Craig Buchanan are on the phone. We have proposed to utilize decorative pavers underneath the canopy, the covered walkways that are in the front of the store. We've agreed to use a decorative pavement material for the crosswalks that cross through the parking areas, which create that definition in. I'll tell you that Publix is adamantly, with a little emphasis added, opposed to providing pavers for the crosswalks. They are a huge liability issue. They obviously operate centers all over. I'm not saying that they haven't done pavers, but I can tell you that at every one of those plazas where they have pavers, they're dealing with lawsuits and liability. And so at this location, at this time, that's not proposed. But what we have done, and Nielsen will tell you, every architectural request that was made of the city relative to architectural enhancements on the architecture, every landscape request that was made, every single one of those, every pedestrian sidewalk connection, the applicant agreed to every single one of those. So I appreciate the concern. Again, that's something that's not a requirement of your code. And certainly, if you want to make it a requirement, it needs to be in the code, not to be just self-imposed onto an applicant. But I caution you not to require pavers everywhere, because there are liability issues that are associated with that. And I can.
What about a more aesthetic like the sales center? There's a bigger type paver block that are joined together. They're actually.
Well, we actually do in the front of the store. That's what you have.
Okay.
So what we're just not doing is in the sidewalk.
You have a plan of this that we can see.
In my PowerPoint, I can present that when we get.
I can specifically point out where are they proposing some decorative paver and where they are not.
Okay.
So, for example, the highlight area here in yellow, that is just concrete. All of this is concrete. So this is also concrete. So where they are proposing the decorative paver is right here in front of this store. So, and that's it. And here a little bit, here a little bit. But for example, you have seen in Alton's or other plazas, they have all of this is decorative paver. All of this is decorative paver. But it's fine. Maybe there could be a compromise.
Well, there really can't be a compromise. We certainly have agreed. We've done something decorative at each of the crosswalks, Mr. Mayor. And in the front, I would tell you, Publix is adamant about this, is that it's a huge liability, and it's not a requirement. It's not a requirement of the city.
We don't have a say in this. In other words, we don't have a say in this.
No, we absolutely.
Well, I think you have.
Is that what you're saying?
No, I'm saying we're listening, but what we are saying is that we're obligated to follow a code, and this is an area of.
Is that the code?
With regard to site plans, as I mentioned before, staff reviews the codes and also reviews the comprehensive plan. So with regard to that, when an application comes in front of council, the council can approve conditions of approval. You know, that's the reason an application comes in front of council.
That's what I thought. But I understand from Mr. Donaldson that that's not the way it works.
I would tell you as a professional planner here in the state of Florida that if it's not required by your code, you can ask for something, but it could not be a basis of denial of the request. So if the applicant said that that's something that we cannot do, and we have a justified reason for it, which is the lawsuits and the liabilities associated with it, I would tell you that that it's not a basis of denial. Like I said, it's not a requirement of your code. I do hundreds of Publix plazas all around. A few of them, a very few of them, end up having pavers in crosswalks or in sidewalks like this, which we are doing exactly what Nielsen showed you in front of the sales office across the entire front of the Publix center. So that's not concrete.
Well, then
it's just the crosswalks where we're not doing it because of the settlement that you end up getting.
That's your question. If the pavers are a problem up in the front, what difference does it make if they go?
Because these are more narrow, defined pathways, and that they're not set on a concrete base. As you know, in the front of the center, those pavers are set on top of a concrete base. They're not sand set or even on set of rock. You don't have complex landscape areas that adjacent to those. What I would tell you is that if you look at the plans that we submitted, those walkways that we've created have lined. They're lined with landscaping and palm trees, and unfortunately, those roots and things do have impact with paver areas in a landscape setting where they're at. So we would ask you please to consider Publix request. If it were something that we didn't feel strongly about, we would just agree to provide it because it's again, you could probably put in a paver sidewalk for not much more than the cost of a concrete sidewalk. It's the liability that's associated with that activity, particularly somebody trying to push. Have you ever tried to push a grocery cart across pavers? It becomes very, very difficult.
The ones up on Town Center Parkway look beautiful. I could ride a skateboard down.
Well, I understand. We're not trying to be difficult, Mr. Mayor, because we really, if you look at the architecture and the landscaping and the whole package that's been submitted, it really is spectacular.
Do you have a presentation of all this so we can visually look at it?
I do. We've been talking about the master plan right now.
Yes, now this is just for the master plan, but then there is a site plan review, another presentation for phase 1 alone.
So where does this paver conversation come in?
In the site plan.
No, in both. Both, because the master site plan is for the entire plaza. So, for example, in the phase 1 is just for for, like I mentioned at the beginning, just for this. So, but for example, here, I don't know what kind of sidewalk will be here for the future when, for example, a high-end restaurant comes around. I don't know what kind of sidewalk. Are they going to put concrete here in front? I guess, here there is a concrete here. I don't know, in front of the bank, so there is not a clear. We have asked. I have worked with the applicant. I have asked in many of my comments, letters, that, so.
At this point in time, seeing that our city code does not require any, payments or whatever, and people are really looking for something to come to the city, I feel we shouldn't make it more difficult for any business trying to come in here than it need be. I'm all about things looking good, but let's bring somebody in. Let's try not to make it too hard for them, and if we want to change that down the line, city code requires certain things. Not for public, for business down the road, not for public.
I got to be honest here, guys. This is our flagship plaza. Right. This is our very first commercial plaza that's going to be in our city, and it's really going to set the trend for how our city looks moving forward. We have an absolutely stunning sales center, which eventually will be retail, I'm sure. Alton just got built, not that long ago.
Yes.
I lived in Evergreen for 10 years.
And rents in Alton with the CAM and everything attached to it are close to $80 a foot. So I don't think that means zero. That means zero tenants, because if the tenant can't survive,
You'll survive out here.
If I think that there's different. It's a different economic scenario.
I would really, really like to see either some kind of compromise of better aesthetics besides simple concrete, or flat out say we got to do some kind of decorative concrete.
Some question, Don, is there a potential for, shall we say, stamped concrete walkways instead, which gives you a more aesthetic site, et cetera?
There's still concerns pushing golf carts and other things. I'll try to reach out to my client when Nielsen makes the presentation on the site plan.
Or colored. I mean, in city of Coral Gables, they have Coral Gables beige sidewalks. Everything has to be Coral Gables beige. Is there something that could be agreeable to publics that gives some different aesthetic look other than just plain concrete? Which I understand, I totally get the liability and the issue, and I also know that's why you won't find any parking stops in any public shopping centers or most other shopping centers because of the hazards for vehicles and pedestrians. So I get the liability. I'm thinking is if it's possible to have something, some kind of a compromise that could give some better aesthetic, whether it's colored concrete or something that could give a better look without having the liability issues.
Yeah, I'll see if
I have the other presentation for the site plan review for phase 1. So we're gonna zero in on what's gonna happen now, right away, phase 1. Yeah, well, but I can show the site plan review in a way he reach out to his clients.
I actually perhaps do both of these at the same time. My presentation is consolidated as one as opposed to two.
Please, I just would like to provide more information because the applicant has cooperated on another term, so that the presentation will cover that.
Real quick, I have a quick legal question. Can we set a requirement, or because it's not in our code, we're not allowed to?
The better practice is to have it in your code if you want to enforce it the way you're saying the golf cart. However, real world, these things are generally negotiated with the applicant as you're trying to do now, because the applicant is coming back and asking you to deviate from your code. And so there's give and take, just back and forth. He wants the city to deviate from the code, you deviate and do something. And so I respect the concerns and a comment, but that goes both ways. The question is, if we try to impose something that's not in the code, you would have a difficult time enforcing that legally. If they wanted to challenge and litigate, court would say, no, it's not in the code. You can't have these additional requirements. Real world, those things are generally negotiated. There are some things where the parties don't agree, and they'll draw the line in the sand. I don't know if this is that thing for public, or if there's compromise. So it's appropriate to give engineering an opportunity to reach out to his client and see if there is a compromise that addresses the liability issues for them.
So I just would like to show, because the applicant has compromised on another aspect, so I would like to show that on the next presentation. Zoe, please, can I show the site plan review presentation?
Just a moment.
Thank you. So, like I mentioned at the beginning, this is the second presentation that is will focus on phase 1, which includes the grocery store. So, next slide, please. So, phase 1 includes only 8.6 acres, and it's the grocery store. The next slide, please. I would like to. So, as I just showed before, this is the entire master site plan includes all those parcels, but this specific application is only for phase 1. So, which includes the 48,367 Publix with the drive-through pharmacy, the liquor store, and the retail office medical building. Next slide, please. So, as mentioned before, additional phases will be determined by market demand and will be reviewed as they come through. It will be reviewed and heard by the City Council. Next slide, please. So, with regard to phase 1, it's only 8.6 acres. So, as I mentioned before, the application includes the Publix grocery store, the liquor store, and the inline retail. Next slide, please. So again, when we say phase 1, because that was very important when we were reviewing this. So what you're gonna build right now as a phase 1? In addition to the building, it's gonna be built the accessways. Those are on the slide. Those number 2, they are going to be built as part of phase 1. So next slide. So it's also going to be built the sidewalk connecting to the multimodal pathway. So that's going to be built also as part of phase 1. It's also going to be built the interior plaza sidewalk. That's number 4. So, and also, as I mentioned before, the concrete slip panel wall up to that point. All of that is going to materialize as part of phase 1. Next slide, please. So, and again, I emphasize the importance of the aesthetics, and that through building architecture, site design, and streetscape improvement. I just copy-pasted from our city's vision and guideline principles. Next slide, please. So, working with the applicant, please take a notice, that was the initial facade facing Persimmon Boulevard. Working back and forth with the applicant, they improved and they provided the second facade. That's what staff does. We work with the applicant. So before it arrives to you, we work hand by hand with the applicant, because the reason why it was very important, the facade toward Persimmon, because it's going to be also a major boulevard. So we could not have the first facade that was provided with the first application. So through resubmittals, and I working with the applicant, with the architect, I personally called the architect, and so they provided this facade, which is much more aesthetic, a big difference. So next slide, please. So these are the other facades fronting Seminole Pratt Whitney Road. Next slide, please. So throughout the site plan review process, we also review all the different criteria per code. Is this application in compliance with setbacks, with building height, with number of parking? So is in compliance with pervious, yes or not? It's a very simple question, yes or not. So as we review, so we work with the applicant. So next slide, please. So that was a part of the, when, to comply with the minimum pervious, So that was the calculation that was done, and we are going to continue tracking down because, like I already mentioned, they are taking part of the rural parkway, which is fine because it's included into their plat. Next slide, please. So that's the section that is they are completing, they are taking from the rural parkway. And as they progress, we are going to keep track how much. Because if they don't apply, if they don't reach the minimum pervious, so they have to have less concrete into their parking lots. So that's the way it will impact their parking lots. So next slide, please. So with regard to the landscape also, as I mentioned before, there will be plantings around the perimeter buildings. So with regard to drainage, next slide, please. Traffic, the total trips projected of this application. Next slide, please. With regard to connectivity, so basically there are, as I mentioned before, for phase one, this is what's going to be built. The interior plaza sidewalk, the two connecting sidewalks from the rural parkway, and the access ways. Next slide, please. And this is what the applicant is proposing. Next slide, please. And this is the difference with the other plazas. So this is Alton in Palm Beach Garden. Next slide, please. Zoe, please. So another plaza, Frenchman Crossing. These are all public plaza. Next slide, please. This is in Sandestin, another internal circulation with pavers. Next slide, please. Delray Beach. In this case, they even proposed the trellis, trellis on top of the interior sidewalks. Next slide, please. This is Aventura. Next slide, please. So this is just to wrap it up what what the applicant is proposing. Next slide, please. This is what we have right now in our city. Next slide, please. So this is just, again, that this is coming in front of council for December. So the signage plan and the 6 waivers that the applicant will be requesting to council. Next slide, please.
Will you get into those actual waivers or no?
Nor at this point. It will be in December. So with regard to engineering, The engineering department is recommending approval of the subject application with the following conditions. There are a number of conditions that the engineering department, and that was part of the staff report on the first page. So number one, off-site dry rotation will be dedicated by separate instrument in a form acceptable to the city attorney. This shall be done prior to issuance of a land development permit by the city. Next slide, please. So with regard to, for some reason, the positive outfall from this site is directed to Town Center Parkway. The applicant shall provide evidence of approval by city of the necessary stormwater system to serve the plaza prior to issuance of building permits for vertical construction. That's condition number 2. And condition number 3, entry and exit points onto Town Center Parkway are approved for the configuration of Town Center Parkway that was presented in this application. If the Town Center Parkway configuration is altered during the land development permit process, applicant will be required to modify the site plan for consistency. Further details about phasing of the work in this application as it relates to the Town Center Parkway construction will be reviewed at the time of land development permits. Our city engineer is here if you have any question with regard to these conditions of approval. Next slide, please. So, let's start the question.
What will the actual technical name of the plaza be? Will it be Westlake Plaza?
Yes, Westlake Plaza. Public as Westlake Plaza.
Public at Westlake Plaza.
There's one question that is troubling me also. On those sites that you showed where they had all the pavers and stuff, were they owned by Publix, or did Publix build it, or were they part of a larger development, or do we know?
I don't.
Because, I mean, if it's part of a larger development, Publix is a piece of it, it might be the larger developer that put in all the pavers, et cetera. So unless we've answered that question, it's difficult.
That would be a good question.
To say, yeah, they do it everywhere, because it might be part of, like the one with the fountain and everything, that's probably part of the larger development of a town center that they've stuck Publix in. It's probably the major developer that did all the decorative portions.
Ken, that's a great question, and actually Don defined Alton also, so he will be able to answer that question.
To me, that needs to be answered for the council, because if you're saying, oh, we need this to do it everywhere, in fact, Publix doesn't, it might be part of a larger situation.
I know that.
Could we still require them to do it?
We can't, because our code doesn't allow us to do that at this point.
Yeah, and just to help you even more agree with your city attorney on that point, there is a case exactly on point about pavers, where a local government effort to require pavers was overturned. It's Powell versus City of Delray Beach. And it says the city is trying to read into the land development regulations, something that does not appear to be in the regulations, because the city has failed to demonstrate that it has the authority to impose such paving requirements. On appellants, we conclude that the trial court erred in granting summary judgment, and it's Tara doing for the Common Walker on behalf of the PDLH property owner. Thank you.
But I think for future, that if we're showing things of where other things are, we need to make sure that what we're showing as staff to council is an accurate representation of what's being asked for.
Do we have the answer to that
Yes,
question?
I mean, he can answer the question with regard to Alton.
I think for the record, done with the hearing, to my knowledge, none of the centers that were presented to you were developed by Publix supermarkets. This one is. Their Alton Town Center was developed by North American. The one that was presented previously, which is up in Jupiter by Botanica, that was developed by Premier. The one that was developed, up there off of Hood Road was developed by another private developer. So they were not Publix. Publix does not do it. Publix does not allow it for all of the liabilities. They just, the issue is, pavers. When you have eggs in your shopping cart, in addition to the other liabilities on pavers, it doesn't, it just doesn't work, and that's why it's not done. And so we certainly appreciate the request. I think that there's a perception just because you have pavers everywhere at the high-end center. That's not true. I mean, the city has concrete on most of its sidewalks, and it doesn't make them not special. Where they use pavers is where it's in an important area, in crosswalks and other areas, to make those areas more important. You just put pavers everywhere.
Let me ask you something, Don. All of these here right in front of the public, there is pavers.
Yeah,
so how are they going to do with the shopping cart and the eggs?
The difference is those would be a very large format paver on a concrete bed where you don't have any movement, and you have nothing that's going to create an impact for tripping and other reasons. Whereas you can't afford to do that in other areas of the center. So,
what about painted concrete?
Stained concrete is something that can be done. It's not out of the question. That's certainly something that we can just discuss as we consider and go through the presentation. I think, unfortunately, you have been given the opinion or the perception that this isn't really a first-class center. It absolutely is. If you were to pull out the landscape plan and look at the details of everything that we've done in architecture, you'll see that this is very, very nice. I know Westlake is going to be fantastic, but it doesn't have the population here yet today. So as you know, and the retailers in the Grove marketplace have struggled, and that's an understatement. So we're very lucky to have Publix here. They're going to be a great addition, and generally what we like to do is they do grocery anchored centers the best. They're one of the best in the country, one of the most successful in the country. And I would ask is let them do what they do best, and I think that you'll be very happy when it's completed.
It's just this being our flagship plaza. I really want it to be something special.
And it needs to be, but ultimately your town center is where you're going to see that level of detail and pedestrian articulation. This is it's on the opposite side. This is not a pedestrian-oriented town center. It's not intended to be. It truly still is on the west side, it's going to be more suburban. We specifically did not put it on the east side. Minto was very selective about where it could go, so that town center has the opportunity when there's the critical mass to support it. And so that's basically what our plea would be with you.
Understood, Don, and I always appreciate your work ethic. I was just talking about you with Chelsea Reed the other day.
Oh, she's a sweetheart.
Yeah, I just would hopefully the compromise, at least to have the conversation with them.
Well, I did get a text. They would be willing to work with the city to do basically a colored concrete, which is from a liability standpoint. We do colored concrete, and then we probably just would do a stamped asphalt in the parking areas, and that would be some contrast. So that is something, but it really is a concern.
And I think at least from my perspective as the manager and looking at this, and Niels and everybody, I think for the council it's something that gives it a little bit of unique character, but saves the liability issue that Publix is concerned about. And I'm concerned about it too, because I don't need PBSO running to trip and falls, writing reports all the time in the parking lot for tripping over that sidewalk or pavers and stuff. So a compromise of that to give it some aesthetic look.
Right,
it's
a huge liability. I mean, you have what I would call the ADA police that come out there and go to every commercial center, just to file a lawsuit, and one paver that's up, an eighth of an inch too high, and it will happen, is a part of that lawsuit. And so it does become challenging. So hopefully this is a good compromise.
They're looking at potential colored concrete and stamped.
Not stamped,
Not stamped,
but
colored concrete, but potentially stamped asphalt.
Yes, through the vehicular use area.
Yeah. I think colored stamped asphalt.
It sure would be an improvement.
Okay.
So if you're willing for that, and then
So that will be a condition of approval for the master site plan and the site plan review then. It needs to be then a condition of approval for the master site plan and the site plan review, both of them.
So can I make a motion to approve both in one shot?
No,
we should do it
each one, but in both of them, that they have the colored concrete and the stamped asphalt, in the drive areas.
So what's the first one?
So, Zoe, read by title Resolution 2020-32.
Yes, I have a resolution 2020-32. A resolution, I'm sorry, no, it should be resolution 2020-33.
33.
Okay, I'll make a motion
I have to read the title. A resolution of the City Council for the City of Westlake, Florida, approving the master site plan for the Publix at Westlake Plaza, containing a fast food restaurant with drive-through on Parcel A, a bank with drive-through on Parcel B, a sit-down restaurant on Parcel C, future retail on Parcel D, and a Publix grocery store with a drive-through pharmacy, a liquor store, and inline retail on Parcel E, located at 16841 Persimmon Boulevard South in the city of Westlake, Palm Beach County, Florida, providing for implementation and providing an effective date.
It would be Persimmon Boulevard West and South. There is no Persimmon Boulevard South. There's a Persimmon Boulevard East and Persimmon Boulevard West. This would be Persimmon Boulevard West.
So which one would it be?
What? Just west. It's just the title.
City Attorney, do I need to reread the title with the correction?
Why don't you just reread it, and that way we're covered.
Okay, Resolution 2020-33, a resolution of the City Council for the City of Westlake, Florida, approving the master site plan for the Publix at Westlake Plaza, containing a fast food restaurant with drive-through on Parcel A, a bank with drive-through on Parcel B, a sit-down restaurant on Parcel C, future retail on Parcel D, and a Publix grocery store with a drive-through pharmacy, a liquor store and inline retail on Parcel E, located at 16841 Persimmon Boulevard West in the city of Westlake, Palm Beach County, Florida, providing for implementation and providing an effective date.
I'll make the motion to adopt Resolution 2020-33 with the conditional approval of the aesthetic colored concrete as well as the engineering recommendations.
The master site plan has proposing, on the staff report, it contains vacant parcels, A, B, C, D, to keep a visual appearance. Will be stabilized, it's much regular mow and receive temporary watering. That was the already proposed condition of approval, plus the one that.
That's in addition to the more aesthetic colored concrete.
I'll second the motion.
I have a motion made by Councilman O'Connor, seconded by Councilwoman Crump. Roll call. Mayor Manning?
Yes.
Councilman Paul?
Yes.
Councilwoman Crump?
Yes.
Councilman O'Connor?
Yes.
Vice Mayor Long Robinson?
Yes.
Motion carries 5-0. Thank you.
Okay, so that'll move us on to 2020-34. That's a site plan for Publix grocery store located at Westlake Plaza.
title, Zoe?
Sorry. Resolution 2020-34, a resolution of the City Council for the City of Westlake, Florida, approving the site plan for an approximately 48,367 square foot Publix grocery store with a drive-through pharmacy, an approximately 1,400 square foot liquor store, and approximately 9,600 square feet of inline retail, located in the Westlake Plaza, located at 16841 Persimmon Boulevard West in the city of Westlake, Palm Beach County, Florida, providing for implementation and providing an effective date.
Make a motion that we move forward with the adoption of resolution 2020-34.
With
Conditions of approval.
Conditions of approval by staff and color
concrete and stamped asphalt.
and asphalt.
we have a second.
I'll second the motion.
I have a motion made by Vice Mayor Long Robinson, seconded by Councilwoman Crump. Roll call. Councilman Paul.
Yes.
Councilwoman Crump.
Yes.
Councilman O'Connor.
Yes.
Vice Mayor Long Robinson.
Yes.
Mayor Manning.
Yes.
Motion carries 5-0. Thank you.
Mr. Mayor and Council, on behalf of Publix Supermarkets and our whole development team, we thank you very much and truly look forward. I think our plans are almost 100% and have all been submitted to Publix for final reviews. So the hope is to get them in here for building permit and start construction as soon as possible. So thank you very much.
Just a question. If the way things are moving along, when would they actually be able to start building?
I'll give you a firm answer on the 14th when we're back before you, Mr. Mayor. But I think it'd be first quarter is when they plan on starting.
And normally, what would the construction time be between starting and completion?
Well, less than a year. So I would probably say 8-9 months.
So by the end of 2021,
I would say
up and all running.
Yeah, they have a method to when they start a store. It's very systematic of when a store starts and when it opens, and this will fit that schedule. So I'll get you all the information for the 14th so that you can be excited about it. I think as we all are having your own Publix right here, so it'll be a special place.
Appreciate it.
Thank you very much for having us tonight.
Yeah, thank you.
Thank you.
Okay, we'll move on. We took care of the old business. So new business, solid waste authority revised interlocal agreement for the delivery of municipal solid waste to designated facilities and for municipal revenue sharing recycling program. Mr. Castle.
Yes, Mr. Mayor and Council, this is a request from the county. They have modified their solid waste agreement and are asking us to sign on to it for the recycling and reimbursement program that they have. It's just an update. They put some changes in the state statutes that required them to make some changes, which we have to agree to.
This doesn't extend their contract, okay?
This is
Nothing to do with this.
Palm Beach County. This is not, has anything to do with the actual waste hauler. This is with the county and the interlocal agreement that we have with them.
So we have to vote on this?
Yes, a motion to approve the interlocal agreement and authorize the manager or the mayor to execute it.
Okay, so we need a motion.
I'll make a motion to enter an interlocal agreement and advise the manager.
Yeah, either authorize the manager to execute on behalf of the city.
Okay, authorize the manager to execute on behalf of the city.
Okay.
I have a motion made by Councilwoman Crump, seconded by Vice Mayor Long Robinson. Roll call. Councilwoman Crump.
Yes.
Councilman O'Connor.
Yes.
Vice Mayor Long Robinson.
Yes.
Mayor Manning.
Yes.
Councilman Paul.
Yes.
Motion carries 5-0.
Move on with item B. This is corrective action for resolution 2020-29, adopting the final ad valorem millage rate to identify the area and reporting percentage and rollback rate.
Yes, Mr. Mayor. It was an error that got kicked by DEO, and instead of making us redo all of our ads and everything, they said do a corrective numbers because it does not impact anything that we've done on the budget.
Okay, so, do you have any questions on this from the council?
As long as the trash bill ends up on the, on the tax roll for next year.
Okay, so, we read by title 2020-35 then?
Resolution 2020-35, a corrective resolution of the City Council for the City of Westlake, Florida, correcting Resolution 2020-29, adopting the final ad valorem millage rate to be levied for the fiscal year beginning on October 1, 2020, and ending on September 30th, 2021.
Motion to adopt resolution 2020-35.
Second.
I have a motion made by Councilman O'Connor, seconded by Vice Mayor Long Robinson. Roll call. Councilman O'Connor.
Yes.
Vice Mayor Long Robinson.
Yes.
Mayor Manning.
Yes.
Councilman Paul.
Yes.
Councilwoman Crump.
Yes.
Motion carries 5-0. Thank you.
Moving on to item C, Palm Beach County Municipal CARES Act reimbursement program.
Yes, Mayor and Council, we received a notification from the county, barely a week and a half ago, saying that there was going to be some CARES money that we could apply for in reimbursements. So we quickly put together all the information, got it into them last week before the holiday. This is the interlocal agreement that will allow them to fund us back. There's a couple blanks in it because they have not decided what the actual number of the ILA, the agreement stuff is at this point in time. That will be filled out as the county gives us that information. But we've already submitted the package to them. This is just the follow-up.
Okay. Thank you. Item D, discussion regarding city attorney contract.
We need to adopt
Oh, we have to adopt
That, yes.
Oh, I thought you were just,
No.
you give us information.
No, just motion to approve the CARES Act
Okay.
reimbursement program.
Mayor, or whoever's going to make the motion, just one thing to add to this, that there are a couple of blanks in here. If the motion can be substantially in this form, that way whatever additional changes the mayor has to make to the agreement, those blanks can be filled in. Right now, it's not complete.
So how would it be ordered?
Motion to approve substantially in the form attached here too.
Motion to approve substantially in the form of that.
Here too.
I'll second.
I'm sorry, I didn't catch who made the motion.
I did, JP.
Seconded by Vice Mayor Long Robinson.
Yes.
Okay, I have a motion on the floor by Councilman O'Connor, seconded by Vice Mayor Long Robinson. Roll call. Vice Mayor Long Robinson.
Yes.
Mayor Manning.
Yes.
Councilman Paul.
Yes.
Councilwoman Crump.
Yes.
Councilman O'Connor.
Yes.
Motion carries 5-0. Thank you.
Thank you. Okay, item D, discussion regarding city attorney contract and accountability to city council.
So I guess I'll start. Are you looking for?
Well, it's an administrative.
Yes, it was requested by Councilman O'Connor to put it on the agenda, so that's what's on the agenda for discussion. Councilman O'Connor.
I'll just make this really quick, and we don't have to really dive too far into it, but I'm sure everybody saw the memo. Attorney Booker has also been acting as legal counsel for other municipalities. I may be completely alone in this, but I absolutely was under the impression that you were our full-time city attorney. I recall not that long ago, you were justifying adding almost another $100,000 in the budget. I actually felt that you were spread too thin because we're a new city and we have to write all these ordinances from scratch, and that you wanted to bring in another attorney to help do so. I just, you and I actually sat in this room, and I have it in my notes. I'm like, when I asked about the budget, and I've never been shy about how I think the legal budget is entirely too high. You mentioned that you actually drew the comparison that unlike Mr. Castle, who actually oversees other districts and has other roles, you were 100% us. It's right above another line where I can't even read my own writing, but I actually have written down no other cities. So I was just completely taken back. I had no idea. I don't know if the rest of the council feels that way or not, but I feel it would have been remiss of me not to get some clarity on that. I really thought, they were spread too thin, just with your role here. So I completely understand your contract does not bar you from working for other municipalities. I read it a few times. I know that. But, legal has absolutely been a challenge recently for different issues and areas, and I just didn't know that you weren't completely out. I've made the comment before that for the $500,000 that is our legal budget, I would want a huge firm with a war room of paralegals and junior associates and investigators and with that kind of money. But, I reconciled with the fact that, well, you know what? Well, we got Pan. Pan lives, breathes, sleeps, and eats Westlake. Completely. And that makes sense. We have somebody who's intimately involved in everything we have going on here and has been from day one. But I was just surprised, to say the least. And honestly, I was surprised more by your answer. When I asked you about it, the answer was a very canned, here's my contract, there's nothing in this contract that says I can't do what I'm doing. I just don't think there's accountability. That's all. That's my comment.
Do we have any other comments?
Well, yeah. Whatever's going on here, I view that as a bullying of the city attorney. I don't know if we would have these discussions if this was a white male or whatever. I don't know. I don't know what's going on here. Something is completely off. Councilman O'Connor said there's nothing in a contract that prohibits her from doing work for anybody else. City manager works on, I don't know how many different municipalities, projects, whatever, for this, Mingo, you name it. I took the time to go over the reviews again. In none of the reviews do I see where the city attorney fails to do her job. Any one of the reviews, or most of the reviews, say there's a conflict between the city manager and the city attorney. That is a crime to do a job. We had this discussion to kind of, get some peace between the departments. And here we are talking about something that, in my opinion, doesn't need to be talked about. This is utterly ridiculous. It really is. It's offensive. It is wrong. This stems from a letter that supposedly is anonymous. I can't think of a person in the city that has any reason whatsoever to hide their identity when it comes to the city attorney. So where's this letter really coming from? This letter is as anonymous as the letter that we had when it came to the election. Why does the person not have to reveal their name? So something here is not right. It seems like there's a force that's trying to force the city attorney out. This in a time when we're about to look at the land development agreement. And who's more knowledgeable about that in this time than our city attorney? Again, I'm outraged by this whole thing. It is not right. And again, Vice Mayor has brought up the fact that our education committee, the diversity therein, and here we are picking on the one diverse person in our city management. So, for what reason? For what reason? She has every right to do what she did. So there's nothing in her contract that says she works from 8 to 5 or from whatever. She works 20 hours one day and not the other days. It's up to her. It doesn't say it anymore. There's nothing defined. This scenario here alone today, and this discussion with Sid, how many hours of her time did that take up just to prepare for that? So I'm outraged by this whole thing, and this needs to stop. You can't bully our city attorney in this way.
Let me be very clear, perfectly clear. This has absolutely nothing to do with race, and to insinuate that it does is offensive. Absolutely nothing. That is ridiculous. It's very simple, okay? I'm talking about $500,000. I'm not talking about the $20,000 copy machine that I'm also very upset about, by the way. This is a $500,000 budget, and I think we should have a full-time city attorney for $500,000. That's all I'm saying. It's nothing to do with the color of anybody's skin.
How does the budget compare to city? How big is their budget compared to?
I'm not charged with city. I'm representing the residents of Westlake.
Well, the residents of Westlake ultimately pay for this as well.
This is $500,000, and Ms. Booker sat right there with me in this room and led me to believe that the big difference between Ken and her position here was that she was 100% Westlake. Those are my only issues. That's it. It has nothing to do with what you insinuate, and that's offensive.
Sorry.
Go ahead, please.
So I didn't know what was going on when I saw city attorney contract on the agenda. I will admit that I was confused by it, but I understood it because I began getting phone calls, and I did get an email about the contract. And I do not, and I want to go on record by saying this because I know some people are probably listening. I don't have a problem with her working with other municipalities because I know that is what happens. I have seen it before, and I'm not discrediting what she told you in regards to working for the city 100%. I did have a conversation with Ms. Booker once I received the email. And I can't say, I won't call it bullying. However, a resident, 3 of them who don't look like me, did make the comment, and I'm glad you cleared that up and everybody, that was cleared up. The comment was made whenever there is a letter written, it's about the Black woman on the dais. And so that is something that I don't want painted here in the city, because I feel as though I have a very good relationship with everyone on the dais. And one thing I want to take accountability for is I'm glad we made a decision with Sid and the city, because I do think we were possibly sending Cam to a gunfight with a knife. Right? I don't doubt that she had the best interest at heart for the city. And so tonight, I was hoping when I came, I knew very clearly a decision needed to be made so that the manager and the attorney could move forward. And I am hoping, and I'm saying it publicly, I am hoping that now that this decision has been made, now that the council has voted mean that. There needs to be some serious culture building in administration. And so I'm hoping that can move forward. Now, if it can't, we really have a hard decision to make, council.
Absolutely.
If we can't, then there is a decision that needs to be made. But I do know, and people don't see that when we come in, we're all speaking to one another. I've never felt, and here's the thing, it's okay for us to disagree and be called out.
Absolutely.
I'm okay with that. When I was called out, I apologized and moved forward because I was wrong. So
that's the way it works.
But I don't want people in this city feeling like I don't feel attacked. I'm not sure how Pam feels. However, I do know that things are going to be questioned, and we have to be. Like I said, Pam and I had a very good conversation about accountability and transparency. I did not question her about the other municipalities, but we did talk about some other things as it relates to that. So it didn't get to a point for it to get on the agenda. However, I must go on record and say as well, I do agree with Councilman Paul when you look at the evaluation. If we were going to talk about Pam's contract, we should have also talked about Keith, because his evaluation, if we think about it, was subpar. And so if we're gonna talk about contracts and work ethic and things of that nature, then I would just like for if it was gonna happen, we should have talked about both of them.
Level ground.
Yeah, it has to be, and maybe I could have said, hey, let's add 10, right? I'll take ownership of that. Then, but I do realize that if we are going to talk about one, we should have talked about the other, because both, they
both share time in other jobs.
Absolutely. Absolutely. Right. And Ken shares one as well. So, that's kind of where I am with that. But I'm hoping, Pam and Ken, that now that we have made this decision tonight, that there could be a difference with culture and climate. And like I said, I just want to go on record with saying that, and I want to go on record with saying, if not, then I'm open.
Take another step.
Yeah, open to doing moving forward.
The only color I care about is green. I'm looking out, I'm trying to be fiscally responsible. I know $500,000 is a lot of money. There's a lot from where it came from. And it may just be my naivete that I thought that Ms. Booker was our 100%, sole asset. But then it was reaffirmed, when you told me that you were, or perhaps I misunderstood. And if I did, then I apologize. But it's just a lot of money we're spending, and I think we need to be responsible. So I don't care about green.
This is not this is just a discussion.
Yeah.
That's why we're here. Discussion. This is not voting on anything.
No, I just felt it has to be mentioned. I didn't know that nobody else thought that this Booker was so.
Well,
As a discussion, is there more discussion?
not really. I just want to add, just for the record, that I agree. There's too much attacking one another here. The culture does be built, and I agree completely. And I had a bit of a concern as far as the budget goes as well when they learned that Pam was working for other cities. But other than that, I don't think it's necessarily appropriate to come out here and attack Pam.
No.
Attack Pam. I mean, it's just bad. So hopefully we can resolve this moving forward and not have any more.
Yes.
That's all
I have one more statement. I'm reading this. City manager said it's unfair to compare Booker's contract to the salary of other cities and county attorneys. As the contractor, she does not receive retirement and health benefits. She also must pay some of her own overhead costs such as liability insurance. So, you know, her salary, when it comes always to question and the money she's getting paid, and I agree that it is a lot of money. It is nothing in comparison to this, which again, the residents pay for as well. This was agreed upon by the city manager, by Mentor, by many other people. So that's an issue that, you know, since that was a long time ago, and to bring it up over and over and question if or what she does.
Well, I think it was just the staff, the new budget, having potentially hire another attorney for help, and then, you know, that was what was brought up.
I remember the conversation being 10 was spread too thin and needed extra help. I remember we talked about that here.
I get that, but who in here was outraged being open meeting? At the last talk about the budget meeting, city manager said that nothing has changed in the budget. Nothing whatsoever. And then I see $90,000 or $95,000, whatever it was, added to the budget. Then it's, oh yeah, got that for another employee. What was the outrage there?
The manager also cut his contract by $30,000 as well. Because
that is not even the point.
Because the council requested to trim as much as I could. I trimmed all kinds of things out of the budget, and we put back in the $90,000 based upon potential need to budget if we had to expand on the contract.
That is good, but you cannot sit here and say nothing has changed and then add on to the budget. There's a number hitting it there.
Let's not get talk about cutting the budget. I don't have the city hall yet. Or I don't have the land, I don't have any funding. So I don't want to talk about cutting the budget right now. Really.
Mayor and Council, I will respond. There may have been a miscommunication when you and I spoke. One thing that's paramount to me is my integrity. I left my last position because I would not lie. My integrity is something I got from my family, my religious upbringing. I will never compromise that for anyone. So I will never misrepresent anything to you. That's just not who I am. That's not the way I do business. The questions were being asked who are full-time people here. We went through Ephraim, full-time, dedicated totally to the city. Zoe, full-time, dedicated totally to the city. Who are the other employees that are not split between city and city? You brought up the question about Kid and Ken and Kemp. I'm very conscious to not bring up the city manager because of the conflicts we have had. So I did not. The question was, are we 100% city? I am full-time city attorney here for the city of Westlake, doing outside work as my time permits, and it's not contrary to the contract. There's no violation there. In terms of the hourly rate, the contract, I want to go to some of those contract provisions so we can have it clear for whoever had the question. The fee is $132.69 an hour when this was created, based on a 40-hour week. This conversation took place with Mr. Carter. But you may work 30 hours some weeks, you may work 50 or 60 the next. I don't want to be bothered with the time sheet. It's a flat rate, I know what my costs are, and that's it. That's where this number came from in 2016. I'm going to share with you that there's concern about the budget. What are we getting? During that same year, a couple of months prior to entering into this contract, the law firm of Lewis, Long & Walker bid on a city contract for city attorney. And I'll be more than happy to provide you with a copy of it. Their rates were $250 an hour, plus $150 an hour for their paralegals. If my contract was at that rate, that's over $520,000 to me. My contract is not at that. When we keep talking about the budget, everyone seems to want to miss. My pay has not changed. There was $100,000 added for anticipation of litigation. When the vice mayor asked the question, do you need a full-time person? No, honestly, I would prefer that money set aside in case we get into litigation because of all the brouhaha about Rick Girolamo, as well as knowing the Indian Trails litigation was outstanding. And as was stated, you guys want to send me to a fight with a knife, whereas the other side has guns, lots of guns. That's a disservice to the city. And my role, again, is always tell you what's in the best interest of the city. I can't defend and represent the city if the resources aren't there, should anything come up. That was the purpose of that budget. And again, the contract provides that fee is increased once you, the council, adopt the budget. Your budget was just adopted with those numbers in there. No more money coming to me than it was last year. But if litigation occurs, you have money set aside for it. So the number that it's $500,000 and that's all coming to me, again, that's not correct. The vice mayor asked the question, if you don't use that money, will it be there next year? The answer was yes. So we've talked about that. You will not find an attorney with my 25 plus years of experience in local government working for $160 an hour. This is not going to happen. And so the city has a discount for what I'm doing based on that flat rate. When you want to talk about cost savings or money, I would suggest to you that you look at some of the other budgets and what's being spent. You already had a question come up tonight. Sid's lawyer has been paid $560-something thousand. Not what their budget is, what they've been paid. I don't get paid that amount of money. I don't care what someone else gets, but if you want to talk about money and saving money, it's not fair to call me out. Do I feel like I've been called out on these issues? Do I feel like I've been attacked on some of these issues? I do, because of my legal opinion. And I told you before, it's not going to change. But I'm happy a decision's been made tonight. I'm going to draft the code according to what you've directed. But I had an obligation to tell you what the law was. And as long as I'm sitting here as your attorney, I will forever tell you what the law is. And that was it. The additional, I want to talk about building a culture. There was a suggestion in the city manager's memo transmitting this to council that I'm audited. That makes absolutely no sense. What am I going to be audited for? Create timesheets for the last year. Do any of you remember what you did last week, every day, all day? I could not go back for the past year and create timesheets for everything that I've done for someone to look at and say, yes, that's right or not. And that's not what the contract says. The contract was available to him to look at and respond to the question. It's a flat hourly monthly retainer. That's what it's based upon. So it didn't have to have those suggestions, even though, that was the question.
Be careful.
Person. You look at the contract language, it speaks for itself. Haven't done anything contrary to that contract. It talks of conflict. If I was representing another community adjacent that had conflict with the city, I would have to come and get a conflict waiver request. That's not the case at all. So those are my comments in regard to this contract, this hourly rate, and I would love for us to move forward.
Pam, I do have one suggestion or comment. I know I asked at the last meeting, I did, and it may be for staff. I know Chloe was looking into it. I want to know what other municipalities do in regard to legal. Do they turn in? How does that look? I want to see how it looks. I'm not saying we have to do it, but if we could see what happens with other municipalities as far as their legal department, I would like to see that. So, for example, even do you turn in a time sheet or what have you? And so if it's both ways, yeah, I would hope that you would be okay with that.
It's both ways. There's a difference in the contracts. One contract is based upon the hours a week. My contract is scope of services for the entire entire organization that Infomark brings to the table to provide whatever services. As a matter of fact, if you all saw the email that I sent out today, part of what I did in reevaluating the contract and personnel, et cetera, we now have a deputy clerk who started today, full-time to here, to make things happen within the same budget that I have. Because I was able to look at my allocation of personnel, time, et cetera, and make those adjustments to make sure that I had the personnel that I needed here for this contract. What you get in other cities, unless it's a in-house attorney, and even that, some of them put in some kind of what they've been doing to the manager, is just like Lewis Long and Walker for Seminole Press, or for Seminole City. You get a timesheet.
So why can't,
You get an hourly because you're billing by the hour.
okay.
And you get, on every other attorney that I deal with that's on an hourly basis, you get an hourly timesheet. You know what they've been working. The council has not received anything about how many hours or what the attorney, other than a brief verbal at a meeting, I'm working on this, I'm working on that. You all have no reconciliation of what has been being done.
We have the same situation with Infomark. Same situation. I don't know what any one of your persons are doing. You want every one of your people that work, who has the floor?
You do.
Okay. If you want to produce, you need to produce time reports for each and every one of your employees. Then, if you're expecting, I think that if you're expecting that the city attorney has to submit that, you say, where's your contract? I have never seen your contract, I don't think. So let's have Infomark's contract so that every one of us up here on the dais can see it. And same way we've seen the city attorney's contract. And then let's move forward. That's all. Let's make it simple. What's good for one is good for all.
Pam, are you good? Are you willing to compromise and turn in a billable hour document?
That's not what my contract calls for. And
Okay, then so why are we asking?
it's not what my contract calls for.
So if it's on
I don't
a
understand.
contract, then I don't understand.
We shouldn't be having that conversation.
Well, we got another year coming.
And if you want to do it based on billable hours, it is not at the rate that's in that contract. As I stated earlier, it's $2.50 an hour. And that number is a lot larger than what the city is currently paying me. So again, if you want to talk about saving money, going to hourly rate and time sheet, not the way to save city money. You can do it. I have no question whether or not I do the work or put in hours. And if you want to go from about $150 an hour to $250 an hour, plus $150 an hour for Ephraim's time, that's $400 an hour to the city.
I voted no on the budget, so yeah, I voted no because of that. If there were numbers I'm clear. But I know there has to be a compromise, and I don't see nobody compromising, honestly. So we can move forward. I just think we got to be able to.
We have any more discussion on this issue? If not, let's move forward. City council comment. John Paul O'Connor.
I just want to reiterate again, my thing is completely different. Sam, I thought you were being overworked and you were spread too thin and you needed help. And then, you sat here.
I thought we moved on.
No,
we're reiterating.
Yeah, I just want to make it perfectly clear that that's all it's about. And then, you said no other cities, and then that thing came out, and then when I asked you about it, the response was this is my contract.
Can we move on? We've already said it again.
That's all it was about.
You have any more comments? Okay, let's move on then. Councilman Crump. Councilman Patrick Paul.
I do have a few comments. Not surprising.
That's all right.
Not surprising. City attorney and public, yes. I have been informed that in COVID cases within the city within the SIT organization. Upon my asking the city manager, he has then sent out the email that yes, there has been these cases. I do not recall being informed by the city manager that has occurred. In this day and age, in this time, I think that is vital information that we all should have, that every resident in the city should have had. Residents of the city go to the little building down here to pay their bills, to do whatever. We are sitting here, but I remind you, at the same desk that city employees sit when they have, or city employees sit when they have their city meeting. I do not know who had what interaction with him. Mr. Castle is a city employee, Have he had interaction with them? I don't know. How far did these cases go? Information should have had. This whole scenario with the city attorney, I think that the manager has made this a personal issue that it's gone to a level it should have never gone. So I don't know if this is the time to make a motion or not. If it is, I would make the motion that we replace Mr. Coffey with another city manager. I don't know, but Infomart being involved in this, what the process exactly there is. But as the Vice Mayor said, this decision has been made or has to be made. I'm pushing for that decision, not in the direction that some people might want it to go, but there have been too many cases where conflict of interest has been apparent, to me overwhelming, and I think it is time to make a decision, and the decision has to be to replace the city manager. That is my comment for tonight. So if that motion, I can make that motion, then, or if it has to be on the agenda for the next meeting. But I think we're at that point where we got to make a decision.
I'd like to respond.
I'll let you have the floor.
Thank you, sir. As far as the notification of a city employee being tested positive with COVID, they are field personnel. They followed the protocol of Infomart. They tested, they were gone. They were 14 days sequestered. Everybody else who came in contact was notified of it, and also was self-monitoring. It has been self-monitoring. The individual has returned to work in accordance with the protocols established by the company. You'll also know that the building department had people that had COVID. They did the same. They had their own protocol. There have been contractors out here that have had COVID, that have protocols. Every private business has protocols to protect the rest of the people. Those protocols were followed. It is a private matter under that company's directive for their personnel to make sure that they do not spread it to infect other individuals. As far as a personal thing, I do not have anything personal against you. You're trying to say something that's not true, Council. I do not have a personal vendetta against the attorney. From my perspective, the attorney did a premeditated attack on me on September 14th that all of you witnessed. Your email and memo said that it was not premeditated. But I ask you this, if it was not premeditated, then how come there were 13 slides that were done in advance? how come there were things that were put on the agenda that were not put on the agenda in accordance with Resolution 2016-1, which was how to put things on the agenda, was not declared an emergency. There were motions starting to be made. It was not in accordance with anything it should have been. Legal should have been saying, hey, I can't put this on. We can't put this on. Your motion right now would be a counter unless you declare it as an emergency to take it up tonight at this meeting.
And I said, if I can't make that motion tonight, then
I understand.
you can put it on the agenda for next time. It's just,
as far as conflicts of interest, what specific conflict of interest have you experienced? Give me a specific.
The specifics to me are whenever there's a decision to be made, you speaking more out of the voice of Sid, more out of the side of mental than from the city. That is.
No, I speak from the side of what I signed up for on this dais when I first came on board, which is for an effective, efficient, simple process that is set forth so that the developers and everybody else knows what's going on. And when it starts to get convoluted and complicated, that's where I say, no, we need to stop that. I've been doing this since 1983. I do not have conflicts of interest. As I stated from the very beginning, as we get into this SID thing, you'll notice that it's the two attorneys and the two boards need to battle it out. Where you go on your decision is fine. If you tell me to go left, I will go left. And if the SID board says go to the right, I will go to the right. And if they collide, then the attorneys and the boards get to fight it out. And when the decision is final by the two boards, then I follow the direction. That is my statement from the beginning. That has always been my perception. Now, people may say, oh, you're pro this, you're pro that. No, I'm looking for dollars on the tax roll as fast as possible to make it happen. And the only way you're going to do that is by keeping it streamlined and less complicated, because it will get complicated over the time. Why do you think Wellington took their 1,340-something pages of LDRs and stripped them down to 350? Because it got too complicated and they were not getting people to go into Wellington and redevelop and develop. So they stripped it. The planning and zoning department people did the entire stripping of the code. The only time that the attorney was involved was for final reading on was it legally sufficient. That is a difference of how you operate a city with an attorney with the proper council manager form of government. What we have happen here is a subversion of the council manager form of government. Because the attorney has stated to me multiple times that she has to be at every meeting in order to do her job. I have not ever had that in my entire career where an attorney has to be at the meeting to do their job. Attorneys are brought in when you need them. Other than that, you use your staff and your administration to set forth the parameters and work with the council to set forth policy and go down the road. Legal's position is to tell you whether legally what you're going to do is going to get you in trouble or not.
Well, how is she going to know that if she's not in the meeting?
There will be discussions.
Words out my mouth.
There's discussions and stuff that goes to legal when it's ready to go to legal, not when you're in the middle of everything and trying to shape the policy. That is not the function of an attorney.
Vice Mayor. All right. Oh, I'm sorry. I did. Have you comments? No. Vice Mayor.
Council comment?
Sure.
Okay. I'm denying who's been part of them. So very quickly, I'm going to run through these, and I have submitted them. I was asking that as we come to the culmination of 2020, I'd like for staff to just highlight some key accomplishments, ordinances passed, completed, staff members hired, project highlights, development, what have you. We had a meeting with Senator Bergman and talked about, the Delsey funds and things of that nature. The state has given the Delsey funds to municipalities, so, I did direct Ken to kind of look into that to see if Westlake could get any of those funds to go towards, one of those new programs we have for firefighters, police officers, school teachers. Tonight, I think, was an example. We have talked about adding residents to the planning and zoning board. You brought that up, so that's what I was saying earlier. We need to go ahead and really move forward with getting 2 residents to get on that planning and zoning board. And if you could, please consider having, coffee with the city manager and invite PBSO to discuss some updates as it relates to leasing. I know I got a couple of emails and I'm pretty dealt with it perfect about, trespassers trying to come to the water park. So maybe you can have someone from that. As the city continues to grow, and if you could talk about, the benefits or lack thereof of paid family and medical leave policy, which has become popular among municipalities. Or if you could kind of,
But we're all contract, so that doesn't.
well, and not now, but as the city continues
But
to grow.
if we stay all contract, then there's no need for that.
Okay.
I'll look at it, but that's the advantage of being all contract. You don't have to worry about those issues. It's whatever vendor you have has to worry about those.
Thank you. And I wanted to talk about what the city is keeping their eye on as far as legislation with the reusable water and things of that nature. I think constituents need to understand that. Moving forward, I'd like for the city to have some type of adoption, and not necessarily ordinance per se, but possibly a ceremony and effort to honor our soldiers. We never do anything to honor those vets or Memorial Day, and so moving forward, I would like for the city to really, especially if we have a Welcome Home Hero program for them, I would love to see the city do that. So, maybe legal and to look into what some other municipalities have. It may not be an ordinance, but something that we could put in place. And then Attorney Booker, when does the Education Advisory Board receive Sunshine Law training?
That has already started last week, and we'll follow up as their schedule permits.
Okay, and then I did meet with some school principals earlier to ask them would they be interested in having this Educational Advisory Council, and they said Wellington has a stellar one. So I met with Vice Mayor Assistant, and she said one thing that works for them is each one of their persons on the Education Advisory Board has a council person that they deal with primarily. And so that way you can have transparency, and we also know if something comes before the council, we're all aware and, able to build. So I would love for us to adopt that model where each one of us have our very own educational advisory person that reports to us or talks to us if they have issues or if they have something they would want us to be aware of, and it works. So, and then I have Vice Mayor to come here and kind of just talk about how it works. And then last but not least, every year I have my very merry mixer. This year I'm not going to have toys donated, but gift cards, and those students at Joe DiMaggio, children at Joe DiMaggio who have cancer will receive those gift cards. So if anyone, the council members, want to donate any of those gift cards, or when I go over, come with and we distribute them, I'll give you the date and we can do that. So students who have sickle cell will receive a bicycle. Children 18-25 at Vita Nova, but then out here in Wellington and to get the gift card. And that's all.
My turn. Okay, request from the council in our October 12th meeting, the Vice Mayor requests a report on the International Soccer Training Facility and Christ Fellowship. And I asked Mr. Patrick today if he would get with Mr. Carter and get some more information on that, what's going on with both of those. At that same meeting, I asked for a report regarding the comparison of city facilities And Mr. Castle, I spoke with him about that again today, and he said that the report is nearly finished.
Almost finished.
Nearly
I
finished.
got the information back from Nielsen stuff and putting it together.
And with Councilman Paul, I've said this multiple times, I still feel that there's a conflict of interest. And it's a hard thing, because I respect Ken for his knowledge of what, to run a city and to run the district. But unfortunately, the weight of what is out there in the administration of SID, being that Seminole Improvement District is governed by 2 Minto employees, which is the majority vote on that board, and the direction. How can someone take direction and be able to make a decision when if the city decides they want something one way and SID wants it the other way? I mean, that's a very narrow sidewalk lockdown. And this time I might make a personal decision that, gosh, I think the city might be the best way to benefit from this, or would be the best way to handle this. And the next time, I think maybe Seminole Improvement District is probably better to handle this, or the decision would be to benefit, and not necessarily benefit. It's just this decision. It's not to benefit anybody. It's just making a decision. I know that the years of experience are valuable, and it's been valuable to get this thing off the ground. And the knowledge that the city attorney brings with her experience over the years to that. I just don't know how someone can answer to 2 bosses and then handle in between. It's hard for me to get that. I just think it would be so much simpler if the city manager was there just to handle city stuff. That's it. And the district manager for Seminole Improvement District was there just to look at the best interest of what's going on in the Seminole Improvement District and handle the water and sewer and all this stuff, and go down, handle the other areas that he's responsible for, and not have to wear half of his hat say city manager on the side, and the other side of his hat says district manager. It's a very tough thing. It's even hard for me to say this, but I'm really, it's a very difficult situation. And that's my end of my comments. Staff reports. We have a report from William Rowley, District Chief, in our packet. It explains itself. Palm Beach County Sheriff's Office. The lieutenant was on earlier. I don't know if he's still there.
I'm still here if you need anything. If you have any questions.
Lieutenant.
Hey, how you doing?
Very good, sir.
The only thing I got to report is the last 2 weeks you've had 0 crime in the city, so things have been going well. The last thing we had a trailer taken about 3 weeks ago off the property, but really everything else has been very quiet. We've been blessed so far.
That's it, sir?
That's it, unless I heard earlier mentioned a coffee with a cop. I'm definitely able to do that whenever you decide a good time is for it, and I'll have one of the District 18 deputies come also so they can answer any questions that directly relate to them.
We'll do it at the December coffee with the manager and have PPSO there as well. I'll get in touch with you tomorrow. Correct.
Okay, sounds good.
Thank you.
Thank you.
Also, Mr. Mayor, on the dais is the annual report from the fire department that came in this morning that I printed out, put on the counter on the dais.
Oh, okay.
That's the colored copy over there.
Okay, yes. Yeah, very good, thank you. County Fire do this, okay? Report city attorney.
Mayor, council, for the December 14th in the packet, you will have the summary for the month that you guys requested at the last meeting, what items, work in progress, if you will. Provide a follow-up to something that city manager said a few minutes ago. Again, my contract has nature services in it, tells what I'm supposed to be doing. My services include representation of the city, working with the mayor, city council, city managers, and all administrative staff. All legal matters related from day-to-day administrative issues, development of policies, and programs from the city manager. So, again, one of the discrepancies that have come up is the parties get involved at the last minute and it's draft this and put it on the agenda without sufficient time to review it, not being part of that discussion process that is taking place between the engineers. I do what they've drafted, what they talked about or whatever. You got the email providing commentary on that. At least not even being copied in the email is problematic. What was more problematic over this past year is being told that staff can't talk to me without consent of the manager. That goes against what's here. And it clearly says what I'm supposed to be doing. So legal is involved, other than when you get to the final review of the document. I'm supposed to be there to help direct, guide the conversation and the direction, and have that back and forth in a healthy relationship with the manager to say, this is good or bad, and here's the pros and cons, and here's the why. And here's what the law will allow you to or not allow you to do, or here's what the code says or what have you. If those conversations take place with legal not being in the process, they can go very far sideways. And all that time and effort has been wasted by staff doing something that may not be consistent with the law. So the city attorney serves an important role other than just looking at the final document and saying, bless this, or make a minor tweak here or there. Not been the experience.
City manager.
I have a couple things on your desk. Also, I put the memo Vice Mayor requested about the social media, and then so we prepared that for me of the other items that we are doing on social media already. Currently, in the month of November, we processed 30 COs of November. As part of an annual update, I'll give it to you verbally, but then I'll put it in a memo format. The building department processed 409 single-family permits. 268 have been received certificate of occupancy. 247 auxiliary permits this year. Total of basically 45 commercial permits. So that's basically the building department has handled 701 permits issued by the building permit department in the last 12 months. And currently they're at an inspection rate of over 200 inspections per day. Awesome. Planning and zoning has done 258 single-family reviews, 4 more than final surveys of 387, accessory permits, approvals, fences, and closures of 129. Land development site plan reviews, 26 design standard changes, 4 master plan amendments, and a 10-year water supply plan was accomplished this year. Engineering has basically gone over 409 single-family residents with 268 COs issued.
They're working hard.
Everybody's working extremely hard and it's extremely fast. And if you haven't gone into the groves, last week, there wasn't anything there. There's about 8 houses out of the ground to tie beam that in a week. That's how fast it's moving.
Well, we're blessed with development. Say that. The public's moving in is going to be a big boost. At least, if nothing else, for the morale of the residents here. So I'm thrilled that we're getting there, and that by the end of next year, hopefully, you'll be able to drive your golf cart over to the public and pull in and go in and get whatever you need there.
Jimmy John's next door.
Just be careful on the cart, please. Okay, this brings us to our public comments on agenda items only. This section of the agenda allows for comments from the public to speak on items only presented on the agenda. Each speaker will be given a total of 3 minutes to comment. A public comment card should be completed and returned to the city clerk. And that is if anybody's still up and awake.
Mayor, I received no previous comment cards. However, there is a virtual hand from Alicia Torres.
Thank you.
Please state your name and address, Ms. Torres.
Hi, Alicia Torres, 5847 Whippoorwill Circle.
Thank you.
I just was wondering, comparatively speaking, how does the 48,367 square feet relate to the acreage Publix? I'm not sure if the Publix representative is still here or not.
No, they're gone.
About an hour ago.
Alicia, I'll check into that. I believe the one in the acreage at Orange is a smaller store. I'll check the distance. The one at Ibis may be closer to the 48. I know that their new size stores are about the 48 to 50,000 square foot range. I'll see if I can find a comparison store for you.
Okay. My next issue is a comment, and I just have to say, I've said this before, you know, I understand where you guys on the city side are coming from. I'm coming from the residential side, and I just have to express my constant disappointment every time there is some kind of new details for an announcement. You know, the 2 7-Elevens, the 3 gas station taco bars, the Publix, which tonight myself and other residents have been waiting literally years for these details. And it's just a redundant, stale, I'm sorry, it's all business, it's not personal, but, you know, just outdated model for a city. And I just feel like we have this brand new baby infant city that's going to look, smell, and act like a 70-year-old person. I didn't buy here thinking this would be just an extension of Wellington or Royal Palm Beach, you know, typical Florida strip mall city. So I'm just wondering where the vision is, where the imagination, the outside of the box thinking is. It's really, really, really striking to me and almost laughable, you know, like I said, that Minto and the developers are trying to present this new innovative city with incubator, you know, spaces and whatnot. And we really are just ending up with the same old, same old. It's 2020. I thought buying in a brand new city that wasn't built yet was an amazing opportunity to live in a great new innovative space. And I really have concerns. So I just wanted to put that on the record. Thank you.
You're welcome. Thank you for your comments.
Are there any additional public comments? Please raise your virtual hand. If you're unable to raise your virtual hand, please unmute your device and state your name and address. Are there any additional comments? Please state your name and address.
I'll just wait.
I thought I heard someone. Is there someone that wanted to make a comment?
Yes, my name is Carlene Millen. I live at 15934 Rain Lily Way. And the only comment or question I would have is there any way to have a standing item on an agenda for residents?
I'm not sure I understand what that means.
It's for public comments.
Public comments.
Okay, so, well, this is my question. I guess I'll have to just come to each meeting and ask it. I've been here now 2.5 years. And just like the previous resident spoke about the disappointment, I used to come to the meetings on a regular basis. And I used to ask and question, well, when are we going to get a town center? I made the comment at the meeting, and of course, the builder was not pleased by that. But as residents living in this subdivision that have been waiting patiently, the transparency is not here. The communication is not here. If residents don't ask, when are we getting our town center? We don't hear anything about a town center, but we have a sign up there that says town center. So I have never, I think from day one when I moved to this subdivision, I was the number one cheerleader for Mentos, the new city, the excitement. I got my sister to move here from Atlanta to actually live here because of the potential. But once again, we are now continuing to go along, and I still don't hear of any plan. So the only reason I ask, could this be a standing consideration? Because if people don't ask, we don't hear about anything until something is done. For example, 7-Eleven and a Publix. My question still is, when I went to sign my closing papers and I met with my salesperson, it was pitched about this grand town center and the living lifestyle that we would have here in Westlake. And so I still ask, and just like she said, it's just business. It is nothing personal. My question is, can we get a regular update, even if it's 4 years from now, and you just don't want to say it, that we're not going to have a town center to then? Can we get a regular update on where we are on the town center that you sold us on when we were at the closing table purchasing our home?
I believe the answer to that question would need to come from the developer, Mr. Card of Minto. That's not a question that we as a council can answer. We don't sit at the table and sign the documents, and I feel bad that you have this, that you feel this way. But the city has now contracted with a social media firm that will start to get out some messaging from the city side. And I think that any questions about what's going on with Town Center, I would go down to the sales center and ask for some clarification.
Okay, thank you. And just for the record, with you being our representative, promoting for our city, I understand that it's not your role, but I hope that you all will take an active role in asking these same questions, because you do represent our residents. I know you're not responsible for the building of the town center, but you do represent us. And even though I've been coming there now for almost a year asking about this, these are the things that residents are talking about. So I will take your advice. I will go to the sales center. I will continue, now that I know that that's the case, but I do hope that you bear some type of responsibility for your representation of your constituents in regard to this, even though it is not you as the builder yourself that will actually be able to give us the town center that was promised us. So yes, I would thank you for that direction. I will take that up with the sales center.
We would like the city to move faster than I think you would even like it to happen. We have tax dollars. We would love to have the tax dollars to put back in, put back into our city and to take over. So it's just as important to us as it is to you, believe me. Do you have any other comments?
I see Alicia Torres. Do you still have a comment, or is your hand still just raised?
Nope. Yeah, just still raised.
Okay. If there's no further comments, last opportunity, please state your name and address. Mayor, I see no further comments.
Okay. Then we're going to adjourn the meeting at 11:15 p.m. Thank you, everyone.
Except you get them all off.
You laugh, I agree.